Everybody, when you speak, lean into your mic and speak up so the recording can pick it up.
Are your mics on?
Yeah. I'm talking to everybody.
We'll speak so you can all hear.
Good morning. This is the New York City Board of Standards and Appeals public hearing for November 25th, 2014. We'll begin with the special order calendar decision items. Item number 1, 32706BZ, 133 East 58th Street, Manhattan.
Good morning, Eric Palatnik.
Good morning. For a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you.
Continued hearing items. Item number 2, 24532BZ, 12305 101st Avenue, Queens. Careful, Mr. Blake.
Morning, my name is Robert Blakeman. I'm the attorney for the applicant, 108 South Franklin Avenue in Valley Stream, New York, 11580. I of the opinion that all the requirements of the board have been complied with, the sidewalks, the fencing, reducing of the covering of the outside stairway, removing that. And I think we're in compliance of everything that the board has wanted. As a matter of fact, we've done more than that. We put new sidewalks in all around the premises, and a cost of $80,000. So he's demonstrated his, my client's intention to satisfy and cooperate with the board.
Thank you. There was just one question yesterday about there was a white truck that had been parked on the site.
Yeah, well, we put signs there, and the photographs show it, that there's no truck parking there, and not more than 4 cars at any one time. But there's people come in at night, want their car serviced in the morning, and they'll put it there. We try to get them out of it, but it's not, the signs are posted.
Okay.
More than that, I don't think we can do anything more than that.
Okay,
But
understood.
you're right, we put the signs up and try to enforce it, but sometimes it doesn't work.
Okay, thank you. And I noticed that you provided an updated affidavit of ownership as
Yes, I did,
requested, so
yes.
thank you. So we can close this. So for a motion to close?
Any speakers?
Oh, sorry, are there any speakers on this item? Motion to close?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
And then set this for decision on 12/16?
May I just ask the board, this extension of time, will that run 2 years, 10 years from today?
I believe it's a 10-year term, yes?
When was the last?
It was originally 10 years.
Oh, it's a 10, sorry?
Ask him when the last.
When did it last expire?
I believe about 6 months ago, it's 8 months ago.
So it will be dated from the date of expiration.
Date of expiration, oh, thank you.
A little
Okay,
shorter than 10 years.
see you again. Maybe.
Thank you.
Thank you very much.
Item number 3, 92157BZ, 6602 New York Avenue, Brooklyn.
Hello, good morning again. Eric Palatnik with good news to report on the plantings. We've spoken to the owner, and they've agreed to install the additional plantings that the board is requesting.
Great.
So,
So could you amend the drawings, please?
We'll amend the drawings to show that.
And the statement of facts to indicate that.
we will do that.
Okay.
And they have agreed to also approach the owner of the building next door to see if they'll paint the wall. The wall has been the target of a lot of graffiti, I know, and then we've been alerted that the city has, through their graffiti program, been coming out and actually removing the graffiti as it gets applied. So it's been an ongoing problem, but we will definitely speak to the owner and see if they'll allow us to paint it. If they will, we will. If they won't, we'll alert you to that.
Okay. When do you expect to hear back from them? You're gonna-
Probably a couple of weeks. It's obviously this week is probably foregone, but we could find out maybe 2 weeks after the holiday. Within
Okay.
those two.
And then how about the information on how the cars will be managed on the site?
Well, the movement of the cars, there's not much to the movement of cars on the site. It's not a very high volume location. The cars are simply stored and parked in the parking slots that you see, the stripes that we've shown on the plans. And when a customer comes in to drop off a car, it's usually fairly quick. It's a car to be repaired, and they come in and they leave, and the car either gets put into one of the bays or it gets put into the lines to await service. But it's not a very high-impact location. I mean, there's probably a total of maybe 30 vehicular trips there a day, if that many.
Okay. Since the plans need to be resubmitted to show the planting, and we also had problems with the drawings being too light, actually, to read, can you have the architect make clear which are the parking spaces? It's not clear whether there are 2 or 3 spaces there.
Yeah, we'd be happy to. We'd be
Or
happy
maybe there are
to.
even 4. It's just really, they're not
Yeah, we'll have
numbered.
them to mention that.
Okay, thanks. Thank you. Any other comments on this? Any speakers on this item? Okay, so if you could, what is 2014? If you could submit by the 9th, you think you
Yes.
can do that? I think we can, I think we could close this. Yeah, I think I can close
Thank you.
this, submit by the 9th for hearing on for the decision on the 16th, okay?
Thank you.
Please do. If you could get back to us sooner about the painting situation, just as soon as you know, let
We
project
will.
manager know.
We will.
Okay.
Thank you.
So just to summarize, we need you to update the drawings to reflect the plantings and the striping.
And the striping and the wall being painted, we'll update you about that.
Yes.
And we'll make sure the drawings are clear, and we'll try and submit whatever we, hopefully as soon as we can, about the neighboring wall.
Okay, terrific. So for a motion to close then?
Chair Perlmutter?
Aye?
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye. Thank you.
Thank you.
Item number 4, 36203BZ, 428 West 45th Street, Manhattan.
Richard Lobel of Sheldon Lobel PC for the applicant. Good morning.
I think the only issue was about the striping, which I believe in your statement of facts, you're indicating that it will be striped,
Correct.
right? Okay. So, and I think there was a question about a sign, the sign that indicates for private use only,
Yes.
that will be installed,
Yeah,
right?
we'd be happy to do that.
Yes, okay. So are there any other comments on this? Any speakers on this item? So we can close this, and then with a submission on the 9th of December for a decision on the 16th. Okay? Does that work?
Yeah, that's fine. I didn't know whether or not the BSA would simply be able to condition its resolutions on striping and,
Yes, it would be
oh,
conditioned.
but I didn't know whether or not that we'd be able to close and grant on today's date, but if we can't, I understand.
Say again.
No,
Wanted to close and grant.
Close and grant, we can, yeah, we can do that.
Okay.
So actually, yeah, we can do that as a condition. Okay, that's all right. So for a motion to close,
Chair Perlmutter?
aye?
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye. And for a motion to grant on condition of the striping and the installation of the sign.
Chair Perlmutter?
Aye.
Vice Chair Hinkins?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you, Madam Chair.
Thank you.
Item number 5, 7612BZ, 148 Norfolk Street, Brooklyn.
Richard Lobel of Sheldon Lobel PC for the applicant. We had a representative of the executive session, so I know the board's comments. We actually were working diligently to produce a street photo montage of the streetscape, which we have done. We received it actually this morning, so obviously it's too late for this session, but I feel that it goes a long way toward providing the board with additional evidence of character, and so we're happy to submit that today. If the board wants us to do that, we can clock that in. I noticed there were some other comments about the nature of the construction at the home. My understanding from the architect, and we can confirm this, is that the existing building is being raised from its, so that it will, it's taking the existing structural elements and just raising them up. I think part of that was the reason that there was a little bit of confusion in the initial review, but what the applicant did was at Department of Buildings, they said, what would take place there was a question as to what they could use to fill in the gap in the lower part of the building, and they determined that a lattice work, some type of structural element would be sufficient there to maintain the integrity of the existing walls. So they did deem it to be an existing building and one that would be able to come in as an enlargement pursuant to the special permit process.
So isn't this a one-story building? The existing
The
building?
existing building is a one-story building.
Isn't it a block, concrete block?
I think what I'll do is I'll have the applicant I'll have the architect speak to that. This is
Yeah.
basically what he's told me from his discussions with DOB.
Yeah, it's just that it seems quite unusual that you would really lift a concrete block
Sure.
structure. And that's not typical of what we saw being done in the neighborhood. It seemed more like you leave that in place and you add to it. Or you demolish it because, for whatever structural reasons.
Sure.
But so, just to reiterate that there is a possibility that the original structure would be demolished for safety reasons, and because there's a requirement to lift the building under code, there may be a different kind of an argument to be made
Sure.
that this approach still qualifies under this special permit. So you should look into that if that's the way the architect is going.
That's fine. What I can actually just, not to go on unnecessarily, but just because the question was raised in the executive session regarding enlargement and what's permitted. So we'll be in either one of two postures. Either we're taking our existing building structure and raising it, which I think is the case, but I'll confirm that. The second would be to the extent that the building was required to be partially demolished. There's existing precedent as far as BSA cases, as far as cases that went as high as the second department, which allowed for an enlargement to constitute actual demolition of an existing structure and rebuilding of that structure. So there was a case we argued actually in front of the second department. It was Lublinsky versus BSA, in which case then acting Department of Buildings Commissioner Hinkson ruled that since the structural elements of a wall were so decayed that they would be able to replace in kind. And so the BSA actually denied that application. The lower court denied it, but the second department ruled that consistent with other BSA precedent, in the case where you do have existing structural elements of a building, which for purposes of a special permit need to be retained, yet for reasons of practicality and safety need to be destroyed, that it can constitute an actual enlargement under 73622. So it's, while not exactly on point, it's very close, and so we'll make one of those two cases to the board. I, again, appreciate the board's continued hearings of this matter. I do have an owner who was extremely anxious for eventually being able to improve their building. So to the extent that whatever schedule we determine can be as brief as possible, we'll endeavor to produce things as quickly as possible for the board. And to the extent that the board is satisfied at the next hearing and can grant this application, we'll be very appreciative.
Okay, well, in terms of that, I think you probably did hear in my comments that at the moment, after a site visit, it's pretty clear to me that on this block there are no four-story houses, or if there's one house that has a very small penthouse that's set back very far from the front. So that in the elevation that was provided by the architect, looks as if it's really a four-story house built full to the street line, but it's not. So if you really wanted to expedite the application, you'd have the architect and the owner work on reducing this to what's closer to a three-story house, so therefore reduce the height of the attic. And there's a strange kind of, for lack of a better word, the word carbuncle keeps coming up on these projects. There's a sort of little bitty house thing that's attached to the top to the attic, and if that could be brought down, or if a dormer could be used instead, that would be much more akin to what you see in the neighborhood. That would very much expedite the review process.
Understood. I think that we're in a kind of a growing period. I think that, as an example, this owner is making every effort to try to come closer to what the board would view to be contextual. I note with some of my fellow colleagues that the community boards here have been supportive of this type of application, but we're making every effort to come closer, and I think that the photo montage is helpful in that, but again, I'll go back to the owner and see what we can do.
And also, I know it's learning process, but axonometrics are done by architects, but I don't know why a lot of the architects I'm seeing seem to be challenged by this most basic tool that you learn in the first year of architecture school, so.
Duly noted.
So that axonometric provided is not the project, it's a project, but
Right.
not the one that's shown in the rest
Sure.
of the drawings, okay? Okay.
Message received.
Okay, good, so, yeah, so if you could then make, are there any other comments on this? No? Are there any speakers on this item? Okay, so our problem is that we have a very, very packed December schedule.
We will take very little time.
I'm not, hold on one second, let me just. On the 9th, yeah. I'm afraid that December 16th is so packed
Yeah.
that we're not going to be able to do it for then. So this would give your client and architect time to make a really gorgeous project that's totally contextual, and just drive up and down that block, or walk up and down the block of Norfolk, and be informed by what you see there. There's actually two houses that were lifted to meet the FEMA regulations, and that's a 3-story house. And so that's what will be typical of the neighborhood if the buildings are lifted, right? So, so the best I can offer is a January 6th hearing.
Okay.
Sorry?
If it's suitable, closing grant.
Yeah, and if it's a suitable project,
Right.
then we can close and grant.
We're, in the interim, we will make every effort to reapproach staff to ensure the
That'd be
suitability of this project.
Yes, that'd be great.
Okay.
Submit to the project
Thank you, Madam
manager,
Chair.
and, yes, okay.
Thank you. So submission on,
Well, it'd be great if you just sort of submitted continuously
Okay.
till you got it right, but submission on, let's see, the 6th,
23rd?
the 23rd. Yeah,
Okay.
I'm trying not to
Officially,
torture your
but we understand.
holiday. 23rd, yeah.
Okay, excellent. Thank you, Madam Chair.
Thank you.
Appeals calendar, decision items. Item number 6, 16214A, 100 Geiger Ridge Avenue, Staten Island.
Hello, Mr. Rampulo could not make it today and asked me to stand up on his behalf.
For a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you.
Continued hearing items. Item number 7, 16212A, 638 East 11th Street, Manhattan. And item number 8, 10713A, 638 East 11th Street, Manhattan.
Morning, Madam Chair, Commissioners. I think, as you're aware, we're going to need to adjourn these cases. I think the Building Department is also in accord with that. There are still 2 outstanding determinations that have not yet been made by the department. They've been outstanding for months now, and frankly, we don't know when we'll get a decision on it.
Okay. So should we adjourn or just take it off the calendar?
Well, adjourn 2 months. Building
Sorry?
Department requested adjournment 2 months.
An adjournment of 2 months.
2 months, yes.
Okay. So we could adjourn it till mid-February, does that sound right? So adjourn till February 10th?
I would prefer the week before, if not possible, February 3rd.
February 3rd? Okay. But then you have to submit earlier, so if you won't have responses ready by then. So it also could be the 24th of February, and you submit on the 10th?
That's fine.
So we're submitting on February 10th?
10, and it's for hearing on the 24th.
February 24th for both, okay.
Okay, thank you.
Item number 9, 24512A, 515 East 5th Street, Manhattan.
Morning, Madam Chair, Commissioners. Marvin Mixner, the applicant. Since the last hearing, we submitted to the board copies of the applications we filed at the Department of Buildings, both a demolition application as well as an Alt-2 application to protect the 6th floor of the premises, and we're awaiting a response from the Department of Buildings. As I mentioned at the last hearing, I suspect that the Department of Buildings will find objection to those applications simply because the sixth floor is not legal until this board approves the two applications pending. And that's what I suspect will happen.
Oh, so you didn't hear, my understanding was that you had already heard back from the Department of Buildings. Isn't that what you said in your papers, that the Department of Buildings responded?
We met with the Borough Commissioner of Manhattan, who verbally told us that that would be a problem. But we hadn't yet filed anything. So now we've officially filed the application to demolish the penthouse and to reconstruct the roof on the sixth floor. We've also, so you'll be aware, we've also vacated 3 of the 4 apartments on the sixth floor, and the 4th one will be vacant or vacated shortly. They're in the process of moving.
So my understanding is that you have already 6A and 6D vacant. 6B will be vacated this month, and what's going on with 6C?
They are preparing to move, and they will be vacating the premises shortly, probably in the month of December, I'm not sure.
Okay. Okay, it's because that wasn't in your papers, so that was kind of glaringly missing.
Well, we didn't have an update until recently as
Okay.
to what happened.
Okay. So,
Now, so that it's our belief, as it was at the last hearing, that the appropriate mechanism for satisfying the board's concern that the penthouse actually be demolished, apart from the history of the same result on East 6th Street, where the penthouses have been demolished, is to allow the penthouse application to be reviewed by the Department of Buildings. If they don't raise an objection, fine, but if they do raise an objection, we presume the objection they'll raise is that we can't issue an alteration, an alt application on the sixth floor until this board approves the variance and the MDL 310 application. So I suspect there'll be 2 objections issued, perhaps not, but I suspect there'll be 2 objections issued, at which point, if the board approves those applications, we now have an approved set of plans, both demolition and reconstruction plans, that we can then act on quickly. So there's no delay in demolishing the penthouse.
so here's the confusion. I thought we discussed this already before, and I think you had discussed it with council. The Buildings Department is already aware, the general counsel there is already aware, that there is going to be an application filed to effectively, to have the effect of permitting you to remove the penthouse. But the application process has to be such that you file to remove both floors, the sixth floor and the penthouse, and then you go ahead, now you have a permit to proceed, you remove the penthouse floor, and then file a post-approval amendment after the BSA decides on the sixth floor, and you file the amendment reflecting no need to remove the sixth floor. So I'm not sure why that's not going on.
Well, let me explain, is that I did have that conversation, and what I suggested was that it creates a safety issue and a serious building integrity issue if we start a demolition process and don't protect the building during that demolition, or at the end of that demolition.
Why wouldn't you protect, well, before we do this.
Let me just do this.
Yeah, okay.
You've asked that we bring along our construction people, and we do have somebody here who can speak to that issue. I won't, but there's someone here who can explain what some of the concerns are about using that approach when we have to leave a building under a state of partial demolition with open stairways for a lengthy period of time. And we're talking about, when we did East 6th Street, it took the Buildings Department 6 months just to approve our demolition application and reconstruction of the roof to protect the building. That's how long it took. So what you're suggesting is that we start the demolition process and leave it sitting out there for 6 months. It causes a problem, but rather than my saying it, I'd like to have our construction contractor present to the board what he believes some of the issues are that preclude us from doing that.
Did you also bring the architect?
I have a resident and the architect. I also have the owner who'd like to address the board with your permission.
Okay, all right, so if we could hear first from the architect, actually.
Okay.
State your name for the record, please.
Yoram Finkelstein.
Hi.
Hello, how are you?
So the question is really this: all we want to do is remove the penthouse, which is effectively a staircase, right? A bulkhead for the stair, right? There's not too much up there, right?
Right.
A little
so
bigger. So
one-
all we want to do is remove the penthouse, close up the roof with finished roofing, effectively, and do that in a two-step process where you file drawings that show both the removal of the penthouse and the removal of the fifth floor. You're just filing those drawings, and then the contractor pulls a permit but only ends up removing the penthouse and closing. We're not leaving it open, you're closing.
Okay, when you remove the penthouse, there are some penetration to the roof, especially the bulkheads.
Right.
That if you remove them as well, you can have an open roof that somehow has to be closed. If you need to be closed, you need a permit to do that. If you don't close the area where the penetrations are, then you're going to have issue with water penetration, and then it's going to.
And, sorry, but why can't you close the roof, say, for example, with the Department of Buildings work out a staging, where you're removing it in stages, where you show a temporary closure of the roof?
Well, they have to give us a permit to do that if they
Yes.
will. But from what I understand, since the sixth floor is not as legal yet, unless you approve it, then they'll not give us a permit.
But we don't know that. We haven't tried.
Well,
right?
that's the conversation that Marvin had with the Department of Buildings.
Mm-hmm. If the buildings department, we know that the building department understands the situation, and we've actually spoken to the buildings department, so they do understand that this is going to be a two-step process. So it seems to me that all you have to do is show the drawings about how you're going to be closing up the roof, and that would be something that would be permitted, but you actually have to file the drawings in order to accomplish that.
Oh, well, if they will give us a permit to construct, and protect the building, that would be a solution. However, if they don't, and they don't give us a permit to do so, then the building integrity is going to be jeopardized because water is going to come to the building, and it's not going to be convenient for anybody.
But, okay, this is a question for the contractor, this part about water integrity, but you have a question?
Yeah, I don't mean to be skeptical, but I'm going to be really skeptical. I think that our staff has reached out to the building department. We've discussed this at length. I don't see that this is going to actually be a problem. You would file for the demolition of the penthouse and the sixth floor. While you have a second case here pending. You have a case pending for that sixth floor. This is done all the time. People come to construct. They decide that they need a variance for something, so they file an as-of-right drawing, get a permit to do that construction, then file a PAA once they've gotten some sort of approval here. So you're doing exactly the same thing. You're filing for what you can do, which is actually the penthouse and the sixth floor, while your other case is pending here. Once that is decided, you file a PAA and all is well. You can continue to demolish the seventh floor as we speak because you'll have pulled that permit. You can tell the building department, look, we're either going to do this as a temporary closure because we haven't gotten a decision from the BSA, or if all goes well and everything moves pretty smoothly, you're going to be closing it up permanently. So I think you're creating a problem that you just really don't have. I think that our staff has been diligent about this, and I would go to the building department expecting to be able to pull that permit in relatively short order.
Would the building department will come to inspect after the demolition of the penthouse?
I would imagine that they would, to make
They
sure
would,
that you've
and,
closed it up.
while we do
and
that-
depending on where you are at the moment, but I don't think you need to to think about this so hard. This has been made pretty simple for you. So I think you need to go to the building department with your drawings, get your permit, show us that you have started the demolition.
Okay, while doing the demolition, stopping at the level of above the 6th floor, okay? Will we be able to construct above the 6th floor and protect the building? That's the question.
I don't think that there's any question about safety and protection with the building department. But I think you just need to file those drawings. Get your permit.
Okay.
Thank you.
Okay, and any other questions for the architect? Thanks. And now the general contractor, if we could do that. Hi. State your name for the record, please.
Damian Smith.
Thanks. So we just have technical questions for you. So when you begin demolition on the penthouse level, at what point, don't you need to close up the staircase first before you start demolition? So otherwise all this debris falls in the staircase?
Yeah, well, it's done part and parcel. Like, we'd have to get into the 6th floor to do some demolition, to run some new pipes for the new roof drains that will be created when the 7th floor is taken off. And we'd have to build the fire enclosure around the stairs, which would take some structural framing, underneath to hold the walls, and to fireproof it from the inside with the sheetrock, and then stucco on the outside.
Stucco on the outside of?
The new bulkhead, the new stair bulkhead, because we still,
the stair's still going to go to the, is there still a bulkhead to the roof? Oh,
because it's
okay.
a fire egress.
Okay, so you still even have a bulkhead to the roof. So you're only removing, wait a second. There's a bulkhead to the roof of isn't there a central stair, that's the central fire stair?
That's all included in the bulkhead that has to be removed.
Oh, so they're all one structure, okay.
And right now, it's inside the structure, so it's light gauge framing with just sheetrock on it.
Mm-hmm.
So that would have to be demolished, and a new bulkhead built with heavier gauge framing that would receive the stucco on the outside and to create the waterproofing and the new roof.
Okay, so first the fire stair on the new roof, which is effectively the roof of the 6th floor, needs to be enclosed. That would be your first act,
Yeah.
right? And then but you also need to protect the unit below, right?
Well, I'd need to get into the 6th floor to do some demolition, to put in new C-joists to hold the new framing, because right now there are 2 exterior walls, and your C-joists come across, which is creating your structure, which are 2 light gauge framed walls. So those walls that's creating the stairwell right now are not structural. So once we take away the 2 side walls, remove the 7th floor, we got to put a roof back on top of our bulkhead. So we got to take down the light gauge framing walls, put up heavy gauge framing to support our structure for the roof.
Okay,
Of the
but
new
that's still
bulkhead.
for the stair.
That's
Okay.
the stair bulkhead, yeah.
And now I'm talking about for the other stairs that are the
Convenience stairs?
convenience stairs, right? Don't those go to the roof, those
Yeah,
convenience stairs?
they go to
so-
the roof as well.
So those convenience stairs need to be removed, right?
Yep.
And then the opening closed up prior to you actually demolishing the structure on the penthouse level, right?
Yeah,
So you'll do that from both the 6th floor and the penthouse level?
yeah. Most of the work is done from the 6th floor,
Okay.
because it'll all go in underneath before we cut out any penetrations on the.
Okay, okay. So what would be really useful is if you could, with the architect, make a sort of a description of the process that you need to go through and give it to us, and then we can, with the buildings department, work out something where it's understood that this is the scope of the work that you're going to have to do, and you'll have drawings that show that scope, so they'll understand that there's an interim construction, even though the permit is to remove both floors, there's sort of this interim construction process that you're going to go through pending a BSA approval. Okay, so you and the architect will work that out together with drawings and narrative, like you described, where you're putting the C-joists and how you have to reinforce the existing stair bulkhead. Okay. Any other questions for, okay, thank you very much, sir.
Thank you.
Mr. Lincoln?
So once again, we will go back to the buildings department and discuss what the contractor just mentioned to the board. But in listening to him, again, I'm just wondering whether that's the kind of construction work on the 6th floor that the building department can approve, given the fact that it's a non-compliant structure.
Right, so that's why we want to have that information, and then we will
Exactly.
contact the buildings department, because just letting you know, we can't approve this application until we see movement on that removal of that penthouse floor. So we're going to be here for a while, unless you...
Hopefully not.
Yeah, so that's why it would be something that would be terrific if you just went ahead and got the permit and worked with us at the buildings department to get that permit, and then your contractor, who's already got a plan, could go ahead and do the work.
All right, well, I would like the owner to say a few words, because, and I'll let her speak for herself, but they've been put in a pretty precarious position since 2006 with what occurred when the BSA overturned the DOB grant. And once again, this is a building, unlike others, that went through the same difficulty, where construction was complete and all the money was spent, including the money for all the fire safety improvements that are in place, and yet the owner still can't get his building closed out. And it's a great
Can't
difficulty.
get the, sorry, can't get the what?
Can't get the building, can't get a C of O for the building, and have the building closed out.
Right, but so this isn't going to, this kind of delay is not going to speed up the obtaining a C of O. Instead, if there was cooperation and movement and removal, then you get a C of O quickly. How can there be a C of O granted now when there is an illegal floor?
Oh, of course not. The floor has to be
So-
removed.
So then,
Okay.
what we're doing, the order that we're doing it in is just as rapid a way as arguably you might do it the other way. Maybe faster.
Well, we'll see. But I would like the owner to say a few words with the board's indulgence.
Okay, thank you.
Good morning, Chairperson, Commissioner. I'm Elizabeth Shaul, owner of 515 East 5th Street, and thank you for your time this morning. I'm here today to assure you that the purpose of all of this is that we are going to remove the penthouse floor of 515 East 5th Street. That's exactly why I'm standing here today. I think we all have a common goal. As you know, 515 East 5th Street and 516 East 6th Street share the same ownership, which the board granted a vested right and MDL waiver. We removed the penthouse on 6th Street. You just heard Damian Smith tell you that we did it. We plan on doing the same thing here at this building. As of November 12th, we filed a DOB application for demolition and alteration, plans to remove the penthouse and reconstruct the 6th floor. And as you heard from Marvin, we're currently waiting DOB review, which could take some time. You've also heard that 3 of the 4 units have already vacated. That's 3 of the 4 units. The 4th unit should be vacating within the coming days, if not within the coming week. It takes time. People live in these buildings. You can't just call them up and say, you need to leave. You have to give them an opportunity. This is their life. This is their home. It's also the holiday season, so we're trying to be understanding, and we're also working with the DOB schedule. So the goal is for them to leave, and they will. We're also eager to commence and complete this work in an effort to bring the building into compliance and put all of this past behind us once and for all. With respect to a realistic and safe timeline, based on our experience from East 6th Street, DOB, as you've heard, can take up to 6 months to review a job and provide approvals for the demolition. However, we really do feel confident that we can remove the 7th floor and reconstruct the 6th floor in a safe manner within 3 months of DOB approval. Like I said, the goal here is to bring the building into compliance as quickly as possible and as safely as possible, with the least amount of interference to the rest of the building. The entire building, other than this top floor, is occupied with residents. Based on our direct experience, the only way to do this, as you've heard, is to reconstruct the 6th floor, prepare it for the removal of the 7th floor, and move on just the way we did on East 6th Street. Let's remember one thing here, and I'd like to make this clear. DOB granted waivers of the MDL. and they interpreted the sliver law. They allowed us to construct these enlargements in 2006. In 2008, as you've heard, 2 years later, after the building was built, they decided that it was done in error and the enlargement was then challenged. To be clear, this was not our error, but we have been paying and fighting for this for the last 7 years. It's a long time. Like I said, we're looking to bring this to a close, put the past behind us. And that's exactly why we're here today before the board to grant we're asking you to please grant the applications so that we can remove the penthouse, we can restruct the 6th floor, and we can bring the building up to compliance once and for all. Thank you again for your time. Have a happy Thanksgiving.
Could I ask you one question, please? Regarding what you did on 6th Avenue.
6th Street, I'm sorry?
6th Street,
Yes.
sorry. You kept the common stairwell to the roof. Did you also keep the 2 private stairways to the roof?
I'm not familiar with the details of the construction. I believe Damien can answer. He's saying, yes, that's what we did, if that's okay for me to ask him. I'm sorry, do you have any other questions? for
Yeah,
me?
my
Sure.
other question is, why do you think that the method we're proposing is any slower than the method that you're proposing?
I'm not a construction professional. I'm not familiar with all of the steps at the DOB. I'm not an architect. So again, I think that those questions are best reserved for the people who are specific to those trades.
Okay, but just to let you know, I think what we're trying to do is expedite the process, not slow it down.
I appreciate that.
Okay, thank you.
Thank you.
Okay. Just some other things that were requested. You were asked to discuss the fire that occurred apparently in 2005 and how the sprinklers, there was a problem apparently with sprinklers. Okay, so, yes, yeah.
Ownership is familiar with that event.
Thank you again. So on March 23rd, 2011, there was a tenant in apartment 3A who was living in an unrenovated apartment, had old electrical. That's part of the reason why we have done all this work to bring the building up to code. Apparently, he had something plugged into the wall, which started a smoke fire. There wasn't enough heat to set off the sprinkler system. The sprinkler system is actually activated by heat. It's not activated by smoke. So this created some smoke. He was nervous, contacted the FDNY, who also came, but before the FDNY even reached the scene, our superintendent put out whatever the heat smoke was with a fire extinguisher. There wasn't even a report made. So it really wasn't a fire.
Okay, thank you.
Sure. And I can assure you that all the smoke systems and the sprinkler systems are working, because we have reports for that. Thank you.
Thank you. And then the other question was, you were asked us to provide sprinkler drawings, which we didn't get.
Yes, we are trying to get, as you know, the sprinkler drawings were approved by DOB. So we're trying to get the approved set of drawings for you, and we should have that shortly.
Okay. And also, the sprinkler reports, inspection reports that you provided only went up to August. We have more up-to-date ones.
Certainly, we could, we've submitted what we got from the company, but we can ask them to update it to current status.
Okay. And also, hardwire smoke detectors need to be shown on the plans,
I believe they are on the approved set of plans.
on the approved set?
Approved set from DOB.
Okay, I don't believe we have a set of approved drawings from.
They were submitted to the board. They were submitted in connection with the variance application, so they may not show up on the MDL 310 app
Okay, could
folder.
you submit them?
We can submit a second set to you.
Yeah, that would be easier to find, at the very least. Okay. Any other questions? Are there any speakers on this item? Oh, yeah. Yes.
Please state your name for the record. You have 3 minutes.
Good morning. My name is Dan Bernstein from the law firm of Arnold and Porter. We represent the Tenants Association of 515 East 5th Street. We were disappointed but not surprised that the owner failed to meet the board's deadline to remove the unlawful penthouse. The owner waited a full month after the last hearing before she sent termination notices to the tenants of the illegally occupied penthouse apartments, giving them until the end of January to vacate. Moreover, the owner did not file paperwork with DOB for the removal of the penthouse until last week, when she filed the inadequate papers we've been discussing here today. Because the board has denied the owner's request for vested rights and reinstatement of the invalid permit, we believe that the owner should seek a new permit through a new application that the DOB can fully examine. Once DOB examines the owner's new plans for 515 East 5th Street, we expect DOB to raise additional objections. For instance, the 4 apartments proposed for the new 6th floor are all too small pursuant to ZR 2821, a quality housing regulation. That provision requires dwelling units of at least 400 square feet in floor area. As a matter of simple arithmetic, it's impossible for the owner to fit 4 units in 1,400 square feet. The owner, therefore, will have to reconfigure the entire 6th floor. We also believe that the 3 bulkheads proposed at the roof level are unnecessary extravagances. From the street, these bulkheads bear a striking resemblance to the penthouse that everyone agrees must be removed. Since the triple bulkhead proposal was not included with the owner's zoning variance application, the board should reopen that hearing to evaluate whether the requirement of a minimum necessary variance is satisfied. Turning back just for a minute to MDL issues, the Tenants Association would like to second the board's request for long-awaited proof of functioning smoke detectors and a functioning sprinkler system. Finally, we again ask that the owner please provide an accounting of the market rate rents she's collected from the 6th floor and penthouse apartments over the last 6 years since this board declared that they were unlawful. We estimate that these rents to be in the range of nearly $1 million, which should most certainly be relevant to any hardship analysis that takes place. If the owner has any objection to providing this accounting, she should present that objection in writing for the board's consideration. We appreciate the board's efforts to expedite this long overdue process, and we look forward to a swift resolution and a lawful compliant building. Thank you for your time.
Thank you. Next speaker.
Good morning. My name is Jasmine Torres. I'm here from the office of Councilmember Rosie Mendez. She apologizes that she's unable to be here today, but has asked me to read her testimony. Good morning, and thank you for once again allowing me the opportunity to voice my opposition for the variance request being sought for the premises located at 515 East 5th Street due to the owner's non-compliance with the multiple dwelling law. This board must decide 2 separate issues with respect to the subject property. One is a zoning resolution case, number 266-13-BZ, which has been deferred until a decision is rendered in the present case. And 2, the case before us, which pertains to the multiple dwelling law. The case before us was last heard on September 16, 2014, at the September 16, 2014 Board of Standards and Appeals hearing. At that time, this board decided that a determination for the variance being sought would not be considered until the applicant showed a good faith effort in complying with the 2008 BSA ruling, which included, among other things, that the 7-story be removed. At the September 16, 2014 hearing, this board gave the applicant 60 days to remove the 7-story. According to the applicant, the appropriate permits necessary for removing the 7-story could not be obtained by the Department of Buildings because the 7-story was not legally permissible as it existed. Chair Perlmutter asked that the applicant do 2 things. 1, contact the BSA within a week of the hearing to notify the agency that the applicant contacted the DOB seeking the requisite permits to remove the 7-story, and 2, notify the BSA if DOB would not grant the requisite permits and/or if the applicant had difficulty obtaining the appropriate permits for removing the 7-story, so that BSA could intervene with DOB. After the 1-week deadline, my office followed up with BSA to see whether the applicant contacted BSA as required by Chair Perlmutter. At that time, there was no such contact by the applicant to BSA. 1 week after my office's initial follow-up, my office contacted BSA once again to see whether the applicant was in the process of obtaining the requisite permits to comply with BSA's 60-day deadline of removing the 7-story. At that time, my office was told that the applicant had contacted BSA and that the applicant was working with DOB to submit the appropriate plans in order to obtain the necessary permits. BSA, however, had yet to receive a copy of the alleged notice served to the tenants of the duplex units by the applicant, informing them that the use of the 7-story would be terminated due to its future removal. Shortly thereafter, on October 1, 2014, I was notified by a tenant of the building that the applicant advertised an open house for one of the duplex apartments, Unit 6D, on StreetEasy.com, a website that allows brokers or management companies to advertise available apartments in the 5 boroughs. The open house was scheduled for Tuesday, September 30th, 2014, 15 days after this board gave the applicant 60 days to remove the 7-story, which comprises part of the apartment advertised. This board also received a copy of the StreetEasy.com advertisement by the attorney for the Tenant Association, attached hereto as Attachment A. On or about October 10, 2014, my office was contacted by a tenant of 515 East 5th Street, informing my staff that at least one tenant of a duplex unit had received a 90-day notice to vacate her penthouse apartment. This notice, however, was not served to the tenant until after October 1, 2014. Serving a 90-day notice to vacate, 16 days after this board gave the applicant 60 days to comply with a 2008 board ruling that the 7-story must be removed, evidences the applicant's clear disregard and therefore bad faith in meeting this board's deadline. On November 20th, 2014, my office received a phone call from a tenant of 515 East 5th Street to inform us that the applicant submitted a packet of information to BSA. The packet consisted of a letter to the chair and commissioners requesting that this board issue a determination on the MDL application. The packet further includes copies of notices of termination served to 3 out of the 4 occupied duplex apartment units and copies of the fire protection system inspection reports for the sprinkler system from March 2013 up to and including August 2014, even though the 7-story had not been removed. According to the applicant's letter dated November 18, can I finish?
Just finish quickly.
Thank you. According to the applicant's letter dated November 18, 2014, the applicant met with the Manhattan Borough Commissioner, who confirmed that any application to DOB for demolition and reconstruction of the 6th floor would not be approved until the building was in compliance with the pertinent provisions of the zoning resolution and the MDL. Compliance, however, would require BSA's approval of the variance application. Although the applicant states that they have filed a complete demolition and alteration plans to DOB, the applicant includes objections they believe will be raised by DOB, which include the building, that the building is non-complying as to bulk, and that the building is not in compliance with Article 7 of the MDL. The applicant also references a suggestion made at a prior hearing where granting the variance for the 6-story can be conditioned upon demolition of the penthouse, which with a sunset provision of the demolition within 3 months. And if demolition of the 7-story did not occur within this timeframe, the variance would be revoked. The applicant, who owns 514-516 East 6th Street, refers to a similar condition that existed at that address where the MDL application was approved for the 6-story, and upon approval, demolition plans were filed and the 7-story penthouse was demolished. The applicant's letter references occupancy and eviction of the 6th-floor duplex apartments as evidenced by their termination notices contained within the packet of information. Lastly, the letter references the sprinkler system reports that were requested by this board at the September 16, 2014 BSA hearing. I'm not sure if I can finish this or if you'd like to stop me.
You have submitted it in writing.
Yes,
and
I have.
actually, I've read it already. So
Okay.
thank
Okay,
you.
thank you.
Thank you very much. Are there any other speakers on this?
Good morning, Chair Perlmutter and members of the board. My name is Maya Kurian, and I'm here on behalf of New York State Senator Brad Hoylman, who represents the district in which 515 East 5th Street is located. He too apologizes that he couldn't be here in person today to testify, but he's asked me to read this testimony on his behalf. Thank you for the opportunity to submit testimony today regarding the appeal by the owner of 515 East 5th Street in Manhattan, requesting a variance from several requirements of the New York State multiple dwelling law. The owner's decision almost a decade ago to construct 2 additional floors, the 6th and 7th, in violation of local zoning and their continued refusal to bring the building up to code does not warrant an allowance by the New York City Board of Standards and Appeals by the New York City Board of Standards and Appeals. As such, I strongly urge you to reject this application. At the previous hearing on this variance on September 16th, the BSA adjourned the decision to November 25th and ordered the owner to remove the 7th floor penthouse by November 18th as a temporary compromise. The BSA then offered to help facilitate the owner's interaction with the DOB in order to ensure they received the necessary demolition permits. To date, neither of the illegal floors have been removed, nor are they in the process of being removed. While in their November 18th submission, the owner cites difficulty in obtaining DOB permits that would allow for the removal of the 7th floor and the construction of a roof over the 6th, it is a problem of their own making. Both floors were constructed legally, and I understand that DOB would have no objection to issuing permits to demolish both illegal floors. However, DOB may find it problematic to issue permits for the reconstruction of a roof on the 6th floor and a legal addition after the removal of the 7th, a complication the BSA offered to help overcome at the September 16th hearing. It is my understanding that despite the previously mentioned factors, the owner has not taken advantage of BSA's offer of assistance in obtaining permits to meet their obligations. I think it is questionable as to whether the owner is acting in good faith and may be intending to delay this process. It was not until October 13th, nearly a month after the BSA's order to remove the 7th floor, that the owner sent eviction notices to the tenants occupying floors that would be affected by construction. These notices were not only issued late, but were 90-day eviction notices, giving current tenants until January 13th to relocate, well past the November deadline, as apparently required by a clause in their leases that was never disclosed during the previous proceedings. I believe that these actions possibly demonstrate an attempt by the owner to undermine BSA's directives. When combined with the owner's history of ignoring agency directives, the failure to disclose this clause to the BSA would suggest that the owner may never have intended to follow the BSA's order. The owner appears to have consistently demonstrated that they have no interest in complying with the law. I continue to believe that the only proper course of action is for this variance to be denied and for BSA to order the removal of the illegal additions. As such, I respectfully ask you to reject this application.
Thank you. Any other speakers?
Good morning, Sarah Romanowski from the East Village Community Coalition. Thank you once again for welcoming our testimony on behalf, or my testimony on behalf of the East Village Community Coalition in opposition to the variance applications before this board regarding 515 East 5th Street. On September 16th, this board issued a firm order to the applicant to expedite compliance with the previous board ruling to remove the 7th-story penthouse. Since that hearing, the applicant has neither secured demolition permits from the Department of Buildings nor exhausted all options for obtaining approval for the work. Specifically, the applicant, to our knowledge, did not seek assistance from the BSA in communicating with DOB, as was offered at the previous hearing. 2 months later, the building is no closer to the removal of the penthouse. We understand that in this period, the applicant has put one of the units on the market for rent while issuing 90-day notices to vacate the other 3 units. These contradictory actions, neither of which comply with the 60-day deadline given by this board, show a lack of good faith on the part of the applicant. As we have argued previously, the approval of the variance is conditioned under the provisions of the multiple dwelling law upon proof of financial hardship. The applicant has collected rent in the many thousands of dollars, hundreds of thousands, potentially more, for 4 unlawful penthouse units, including since the September hearing. They have collected this rent without providing necessary safety requirements for tenants operating without a valid certificate of occupancy and without a written report on the sprinkler system as previously discussed. We urge that the BSA deny the variance request to the MDL and further compel the removal of the unlawfully constructed and occupied penthouse. Thank you.
Thank you.
Good morning, Chairwoman and Commissioners. Thank you for the opportunity to testify before you today. My name is Karen Lowe with the Greenwich Village Society for Historic Preservation, which is the largest membership organization in the East Village, Greenwich Village, and NoHo. 2 months ago, this board gave the applicant a crystal clear directive: come back to us in 60 days with photos showing the illegal penthouse has been removed. With this case stretching back the better part of a decade, the interested public who was here that day, the East Village community, and the tenants of 515 East 5th Street were all very much looking forward to seeing those photos. But the applicant has not removed the penthouse. He did not accept the chairwoman's offer of BSA help to cut through any DOB red tape. He did not give tenants in the affected apartment notice to vacate until 1 month after the directive. In fact, weeks after that hearing, an open house was even advertised to rent the penthouse. the disregard the applicant has shown to this board, the public process, and the affected residents, all while collecting illegal rent he has not bothered to account for, add up to providing no reason for a variance to be granted. We ask that the request be denied. Thank you very much.
Any other speakers on this item? Thank you, Karen. Want to respond to any of those comments?
I've responded to most of them in the past.
Okay.
It's just a curiosity to me that the tenants who are the beneficiaries of the improved fire safety in the building, which was only constructed pursuant to a permit granted by DOB and only constructed because the enlargement was built, are complaining about it. Complaining about an enlargement which gave them the benefit of having a fire-safe building and a building that is certainly improved from a fire safety perspective from what they had before. And I can only attribute this to some sort of a personal animus against the ownership, but that's neither here. That has no place in these proceedings. The owner has acted honorably. The owner has suffered through 7 years of a situation that was not of their creation. As we've stated in prior hearings, the DOB examined these plans at the highest level and approved them. These enlargements were built pursuant to those plans, and it was only after construction that this board overturned DOB's process and created what is the quagmire we're still suffering from.
Could you just comment on the advertising for the one unit? Is that, have the
Yeah,
owner respond? Or?
Well, I can respond also,
Yeah.
because I've asked the owner about it. They have quite a few buildings. They send it to one particular agency who puts out advertising, and sometimes, no? Okay,
So let
answer.
the owner respond. Yeah.
Fine, thank you.
You need to come to the mic.
And identify yourself.
Elizabeth Shaul again. I don't recall which apartment it is, but one of the apartments in the building, one of the residents, before we notified him that we were going to be serving him a notice of vacatur. And if I could back up for just a minute. Again, because we're dealing with people and their homes and their lives, instead of just sending something in the mail that says, please be advised, you have 90 days to vacate your apartment, that's really not an ideal way to deal with people. We took the time to call every single tenant individually. And after we had conversations with them, advising them of their options, you can stay for 90 days, you can vacate right away, whichever you prefer, we're here to work with you. We've been helping them. Before we had an opportunity to speak with all the residents, one of them didn't know that he was going to be asked to leave. He wanted to get out of his lease early. And the way to do that is to find another tenant to take over the balance of your lease. He had reached out on his own, unbeknownst to us, to a broker, and asked that broker, I think his name was Mickey Benzakane from, I don't recall the name, maybe The Search. He asked him to rent the apartment out, and then we had heard about it that same day. It was printed online on the wire, and we called him right away. We called the broker, and the broker said, look, the tenant called me, and I put this out there. He then heard back from whoever the reporter was and put it on the record as a matter of record, and you can read it online, that he himself was contacted by the tenant, not by us, because we knew we were vacating the top floor of the building, and he explained to the reporter what had happened and that it was not the management company or the owner that had reached out to him. So I hope that clarifies. If you have any questions, please let me know.
I just have questions about the drawings that were submitted, the ones that I assume were going to be submitted to the DOB that represent the removal of the penthouse. So after that very helpful explanation from the contractor about what needs to be done on the 6th floor for the bulkheads, I'm looking at the roof plan, the proposed roof plan, to show the bulkheads and their enclosures, which are significant fire enclosures, which is required. But I don't see any work actually shown on the 6th floor to accommodate that. I mean, this is heavy, I don't know whether it's masonry or sheetrock, I can't see because the drawings are too small, but on the screen. But I don't see that there's work proposed on the 6th floor to accommodate that work. So it's kind of an incomplete set with respect to that. There really does need to be a complete set of drawings that show that proposed change, so DOB can review it for structural integrity and so on, and that would be something that's kind of a set that's a little bit like on an aside, in addition to the set that would show the removal of the sixth floor, just so that you can pull your permit.
Right.
I mean, actually, probably the sixth floor drawing, let's see, the roof drawing in both cases would be the same. So you don't have to do that drawing twice. Maybe you just delete the staircases that are convenient stairs to the roof.
Right. I'll take a look at the drawings we submitted to you, but there should be two sets. One is the demolition of the penthouse, and the second set for the reconstruction of the sixth floor.
Well, it's not two sets, it's a whole set of drawings. So I'm looking at drawing A5, which is the proposed floor plans, and bubbled on those drawings are the changes to the proposed roof and the proposed bulkhead plan. And based on the conversation and looking at the drawings, I see that there need to be changes made to the sixth floor to accommodate that bulkhead framing. So I'm not seeing it being picked up. I do see, no, so the boiler flue is the only thing that I see that was existing. So yeah, the drawings need to be put together better. We don't have a lot of time. They need to be done fast.
Well, what the board's suggesting, though, is that we produce or we file sixth floor demolition plans, which requires reconstruction of the fifth floor, which is an occupied floor. Right?
Reconstruction of the fifth floor?
Yes, right.
No.
Any plans that we file,
No, you don't need to require reconstruction of the fifth floor, because it's just, in the fifth floor, it doesn't have staircases going to the roof, convenience stairs. It only has one bulkhead.
right?
So what you're doing is simply enclosing the staircase to the roof, right? It's the same drawing effectively.
Well, I'll check with the contractor, but I believe it will require work in terms of utilities and other services that require, and also the openings that require some work on the fifth floor. I can't believe that it won't.
Well,
But
this is really questions for the architect,
Right.
and the architect certainly knows how to remove
Sure.
a roof and show the drawings. I mean, I don't think it's a significant amount of work to do the drawings. I'm not saying it's not a significant amount of work if you actually had to remove that floor, which is not what you're being asked to do. It's just to make the submission complete, right? And also have a submission where we discuss with DOB how you're going to stage this. So DOB isn't approving something that's not legal, they're simply approving a staging.
Mm-hmm.
Okay?
Okay.
Okay, any other comments? Okay, so to summarize, and please, if I missed something on the summarize, please add. Okay, as soon as the apartments are in fact vacant, if you could, or some of them are apparently, if you could show photos of the vacant apartments, that would be great. Then you need, or simultaneously, the drawings have to be quickly modified to reflect the removal of the fifth floor. I'm sorry, the sixth floor, the removal of the sixth floor and the penthouse. And then also a set of drawings provided that are similar to what you've done already, but make sure that you've tied the roof into the sixth floor work, because I'm not seeing all the work being done there. And that will be submitted to the buildings department for permit. BSA is in touch with the buildings department, so can help expedite the permitting here, or approval of the drawings and then ultimately permitting. And then the other thing is submission of sprinkler drawings.
Yes, the approved sprinkler plan.
The approved sprinkler plans, submission of up-to-date sprinkler inspection reports. What else did we say? A set of the actual approved DOB set, the original approved DOB set that you said was submitted with another part of the application. And to make sure that the drawings show hardwire smoke detectors, but that would be on the approved DOB set. Right, okay. Okay. And did I leave anything out?
Just the narrative from the contractor?
Yes, oh, and that's right. And
I'm sorry, you were saying.
Okay, sorry.
A narrative?
And then the other was in connection with the architect preparing that sort of, that staging drawing. It would be working with the contractor to get a narrative so that we can all be very clear about what work is going to be done in that kind of interim period so that DOB can issue effectively a partial permit, which actually has been done also, right? A partial permit for removal of the sixth floor pending. I've worked on a project personally where that was how it was handled. Maybe that's a way of handling it. Okay. And then if you could, just in response to comments from the public, if you could respond to the comment about the size of the units on the sixth floor, that they in fact comply with zoning and building code, show calculations, show applicable code requirements for those units. Okay, that are now smaller because you've removed that the penthouse part.
Right.
Okay? All right. You can. No. And the bulkhead what? Three bulkheads there. No, but yeah, no. Yeah. No, that one I see. Okay. If you have questions, feel free to come up and ask the questions directly.
We're just looking at timing, that's all.
Okay. So for a lot of different reasons, including the interests of the owner, we really need this to be done quickly. So I'm not sure, I mean, if I were working on this would take, 2 weeks to produce the drawings, and you get them in, and then at the same time, we're making phone calls. You already have drawings that are submittable where we can have these conversations with the Department of Buildings. So how about in 2 weeks, you submit drawings? Does that work?
We're moving our office at the moment, so we're going to set up back again in maybe middle of next week. Then after that, about 2 weeks.
2 weeks.
Like about 3 weeks.
3 weeks. So, sorry, wrong calendar. 3 weeks. So submit drawings to us on December.
16th.
How about December, not 16th, because it's right before. How about submit drawings to us on December 12th?
Okay.
Okay. And the rest of the submission as well.
Okay.
And submit drawings to us and simultaneously to the Department of Buildings.
Of course.
Okay? And so we want to see that you've actually submitted, so proof of submission. And all of the other things that I listed previously. A lot of that's your work, so.
Understood.
Right? Okay. And then, okay, the 12th. We can't do it for a hearing on the 16th, no way. So for a hearing on January 6th.
Opposition.
And opposition. So there'll be a submission on the 12th of December. If opposition wants to submit, they can submit by the 23rd of December for a hearing on January 6th.
Can we have that hearing on January 13th? Because I'll be out of town on the 6th.
Okay, the hearing can be on January 13th, but the submissions, we're going to be getting back to you. If the submissions are not adequate, we'll get back to you through the staff, okay?
That's fine.
Okay.
Okay.
Thank you. Okay, thank you.
Thank you.
Item number 10, 1114A through 1414A, 4704, 4706, 4708, 198th Street, Queens.
Morning, Madam Chair, Commissioners. Irving Minkin for Shelton Lobel PC. I was the author of the letter submission of November 20th, responding to the comments that the board had made at the last hearing, but also it was focusing on the comments of the community board in a letter submission to the board, and also of the not yet crystallized input of the fire department. So the letter main focus unfortunately didn't address the issues, some of the issues that the board had asked to be addressed. Point was focusing on pointing out why this was not a general city law application. And what we did was we submitted records of prior actions by this board over the past decade and a half that showed that, notwithstanding the concern of the community board as to crowding, as to adjusted construction in a low-density zone, that on the other side of their district, it was a similar situation, only more so. There was 5 building sections for a building that was built as of right. But the building department had no concern about the frontage requirements, about general city law, nor did apparently the fire department. And when an application had been filed in the bed of a map street right adjoining that, it was clear from the photographs that the access for the fire department was encumbered with parking that was required for the as-of-right scenario. So simply put, the indicated that was part of the rationale why we felt that a general city law 36 application accompanying this common law vested rights application was not necessary. Another component of the reasoning behind our non-filing of a GCL 36 application, companion to the common law vested right, was the application on East 83rd Street in Manhattan, where, apart from the zoning issue, the building frontage itself was deficient, and there the Board of Standards and Appeals, with the input from the fire department, was comfortable with the fact that the building department correctly did not require compliance with the frontage because the building was fully sprinkled, even though the rear of the building was set back from the street line a distance equal to and exceeding the situation under this current scenario. So our letter was focusing on that, and I apologize for not addressing the other items. We will address them in depth before what we, of course, expect to be a next hearing. But if the board, I would like to alert the board as to why on some of the items that were raised at yesterday's executive session, why some of those items will not be, we'll clarify it, we'll prepare an amended statement of findings, and between the letter of submission and the amended statement of findings and the collateral documents, we believe we'll be able to satisfy the board that all of the issues, the common law vesting, as well as the issues that arose in the hearing, will be satisfied. I would like to rapidly go down the list to alert the board as to the direction that we're going. First, the statement of findings didn't discuss the 8% frontage on 198th Street. Well, a little further on, the board wondered why we're not having the street open. Well, the portion that's in the bed of the map street of 198th Street partly lies on the client's property, partly lies on the property adjacent to this property. We do not believe that street will ever be open. We will contact the highway department and the borough president to ascertain if our assumption is correct. But we believe that the frontage properly belongs on 47th Avenue as opposed to 198th Street, notwithstanding the house numbers being on map 198. And that's where the similarity to these other cases falls in place. The applications for the other buildings that a decade and a half ago, in part addresses the comments of the community board as to congestion. It's the same zoning district. We have less congestion than was authorized off Little Neck Parkway on the companion cases submitted before. And we will believe that the community board concerned about the fire department will now be put to rest in that we have discussed this informally with the fire department. They have submitted a letter now of last week stating that if we sprinkle all the buildings, which they were given understand, that they have no further concern about fire department access, except that an issue on parking limitations on 198th Street. Well, we don't believe that the 198th Street will be opened, will be taken by the city and paved in what is now the client's property and the adjacent property owner's property. But we will contact the highway department to see if they are amenable to such signs, regardless of whether the street is extended. But our client has indicated that they will sprinkler the entire building, which has greater frontage than the 8% frontage when viewed from 47th Avenue. So we believe, and we will address that in our amended statement of findings and the submission letter satisfying this board that fire department access and street frontage are non-issues. The as-of-right drawings, we concede, are confusing. As I said, it was not our main focus in our last submission. We will correct those deficiencies. We hope to your satisfaction that indicate the extent of removal and expense to the client of bringing it into compliance with current requirements. Now, obviously, consistent with that, we will have a detailed financial analysis to indicate the hardship to the client if this common law vested application is not granted by the board. I believe these are the highlights of the response that we intend to prepare to this board. The one thing that's missing is the amount of time. The last submission time was short. We had to do some research. We had to reach out to talk to the fire department. So the time was unfortunately, unintentionally inadequate for us to do a proper presentation. And we would like to ask the board at this time to afford us 4 to 6 weeks for submission, and then obviously a hearing date a week or two after that, at which time we hope to be able to satisfy this board that the hardship is justified, quantify it, present it well on drawings, and submit all the proper documents.
Okay, thank you for that. So with respect to the access question, so what you've got here is 4 separate houses. Each house, with the exception of one of them, none of the houses have frontage on a map street, on an open street, an improved street, right?
They front on a map street, but not open.
Well, it's not open, so it doesn't sort of do anybody any good because it's not open,
Right.
right? Okay, so that's the part I'm not getting at all. It's not one building that's fronting on 47th Street, it's 4 buildings fronting on 47th Street. And so that is the standard application for a GCL 36 waiver, right? So the case that you cite on 83rd Street isn't relevant because those are 3 buildings that face 83rd Street, and it only had to do with whether the perimeter of one of the buildings was too long
That's
to
correct.
qualify for 8%, right? So that's not what this is about. This is
Well,
about each building.
It's collaterally involved in that the deficiency in frontage on 83rd Street was offset by sprinklering the building. And
Correct,
that's what we're proposing to do here.
But this doesn't have any frontage. These buildings have 0 frontage, so it's offsetting with sprinklers with 0 frontage means you need to get a waiver, and the relevance of the fire department waiving in is whether the BSA feels that it is adequately safe to issue the waiver, that the fire department has access. What you're trying to do is using kind of inapposite case law to get around applying for a GCL waiver, and since you're here already, I'm not really sure what's the big deal. Why don't you just apply for the required waivers?
No problem, Madam Chair. We will do that. I was trying to explain why we didn't think we had to do that, because physically, the scenario here was similar to that for 5 building sections in one structure that faced Little Neck Parkway, and while there was a wider access up to the 5th building, it was cluttered with required parking spaces. So in reality, it was a deficiency that's similar to this. But we have no problem. We can amend the application to reflect a request for a waiver of Section 36 of the General City Law, and we'll make our case based on the facts that we will go into detail in that show that the bottom line is there's safety, there's adequate fire department's access for the structure per se, which viewed from 47th Avenue has twice the frontage that's required by a law of 8%. It has about a 20% frontage as of the perimeter of all four structures added together. So we will point out that
it's not
fire
one structure,
safety-wise,
four.
fire department access-wise, and general access, it meets all the requirements that the board might have addressed.
Okay, so then you're showing also on this drawing fire access that parallels 198th Street. So if I understand this correctly, this is an area that will be paved and improved by the owner,
Well,
is that correct?
No, what that showed the hardship that would have been created by putting that there, but that's not what we wish to do. That's not what we think has to be done. What we are simply doing is saying that with the frontage of 47th Avenue, with a wide triangular portion of mapped 198th Street on the client's property that has to stay open unless it's taken by the city and open as a street, that we in fact meet the intent of a waiver of Section 36 of General City Law without the required removal of portions of the building to put fire department access on the other side of the property.
Okay.
So we will clarify that in our submission so that it's clear that consistent with our submission, our amended submission, an amended statement of findings and supplemental GCL 36, that we would just simply explain what is a hardship, what the hardship would be on literal compliance, and what we propose to do, and explain financially what the practical difficulty is and the cost and the hard financial cost of that literal compliance.
Okay, so I need to go back to this fire access lane that you're showing on the drawings, okay?
It was not intended to be the desired goal. Quite the contrary, it shows how devastating it would be.
But still, how does the fire department get to the last house to fight a fire? There's only a fire in the last house. There isn't a fire in the first house.
There's the triangular portion of the lot, which falls in 198th Street, is over 30 foot wide up to the beginning of the last building.
Okay, so that's effectively fire access,
That's
right?
fire, yes, that's
Okay.
fire access.
So to be
But we're
sure-
having belt and suspenders here. We have fire access up to the edge of the building, and we're also sprinkling all the buildings. So the possibility of a fire or any hazard or detriment on firefighting operations, we believe, is nil, given that belt and suspenders we
But
think is
okay,
there.
so let's just talk about the belt, or whichever one is the suspenders. Let's talk about the belt. The belt is that 30-foot width where the fire truck, because that last house in the row is seriously engaged, right? The fire truck drives along that route there. That area needs to be maintained basically clear of obstructions, right?
Yes.
So effectively, you're going to be landscaping it or paving it or something, right?
Well, theoretically, yes, we will address that anew to make sure that the access won't be impeded.
Okay, so it's going to be paved or improved in some way.
Yes.
So isn't that the bed of a map street?
Yes.
So don't you also need a GCL waiver to build improved in the bed of a map street?
If that's what the board wishes, yes, we would ask for that, but we're not building a structure. We're simply putting a paved area in what, if the city takes the property, would be a paved roadway. And on that same vein, the fire department has additional access to that last building. It can come up what they say is a narrow 198th Street, and at the very edge of this property have access to the last building from 198th Street.
Okay,
So while on paper it doesn't look as good as it sounds, in fact, I would suggest that the fire department access to a sprinklered building at their discretion, coming in from 47th Avenue or coming in from 198th Street, is as safe, fire protection-wise and fire department access-wise, as the other building sections.
Okay, but still, you're improving essentially mapped street by paving it, by putting a swimming pool in front of it, whatever it is you put there.
No swimming pool.
Okay, no swimming pool.
Nothing but access.
Okay, so therefore, it's an improvement in the bed of a mapped street, which we don't have the authority to permit without a GCL waiver, right?
Yes.
Okay, so I think you've got two GCL waivers there. And in the example that you gave, the other case that you cited, that actually did get a GCL 35 waiver.
I understand, but
Okay.
the irony is, had an address on a street that no longer existed, never existed, and we think the fire department would need radar to find it, because the real access was from Little Neck Parkway or from a street that dead-ended there that's narrower than 198th Street. So that's the point I'm making, that we are providing, in my estimation, substantially greater fire protection and fire department access than exists in other portions of this community board's domain. And we feel that we're bettering the scenario here, as opposed to what has been authorized, whether knowingly or unknowingly, in prior years.
Are there any? Yeah.
You have a builder's pavement plan for 198th Street?
We have a pavement plan. We're going to
you gonna
revisit
have to
that. It was I understand it was self-certified, and it included a pavement plan on the map, the 198th Street, that we will discuss anew with the highway department, because we believe we may have to amend that, and also or ask them permission to approve paving in the open space of the map street. I'm not sure how we will address that, which is one of the reasons I would request of giving us 4 to 6 weeks of submission time.
It wasn't clear to me from what you've submitted where the curbs are, where the sidewalk is, and what exactly you're proposing in terms of actual access to the last house.
All right, but what I'm saying is, I'm not sure, it was submitted, it was self-certified. I'm not sure that we want to submit this to this board. I believe we may want to amend it.
Well, we should have that information.
Yeah, absolutely, we will.
You know, part of the confusion here is normally you would just need to improve the bed of 198th Street as part of this development, right? So that's the confusion. The initial review of this, probably by DOB too, so I think that they didn't understand, was that there was clear access from 198th Street because the owner is supposed to improve to the midline, right?
Yes,
And then all of a sudden we learn it's not being approved to the midline or at all line, and therefore you need a different kind of an approval. That's what the confusion is. The application really wasn't clear, and I doubt DOB was aware of it if they approved without.
I can understand, I agree that there's grounds for confusion, and we're going to try to put it together as best as we can to everyone's satisfaction at this point. We believe we've met the wishes of the fire department. I believe we've indicated why the community board's concerns really are not realistic concerns vis-a-vis this premises, and we're going to now focus on the main event, all the concerns of this board.
Okay. Okay, so are there any, I think Commissioner Otley Brown, you had comments about the financials that you wanted to?
Right, and the applicant just said that they were going to address it in the next submission.
In the next submission, okay. So you heard what the requests were from yesterday's review session, so we don't need to go through that again, or maybe we should?
I have it in front of me, paralegal took excellent notes.
Okay.
It's a very, well, let me politely say, it was a lengthy wish list. We intend to comply with it fully.
Okay, great, thank you. Okay, are there any speakers on this item? Yes, there are.
How are you?
Good morning.
Good morning. Good morning, Madam Chair and Commissioners. Senator Tony Avella in opposition to the application. I've just submitted written testimony for all of you. This application attempts to revive construction at a site that has remained abandoned for more than 7 years as a result of the original owner's inability to obtain a certificate of occupancy and as a result of the Yard's Tax Amendment zoning changes which make the current configuration of this multifamily development out of compliance with the current zoning regulations. I submit that the new owner of this property fails to meet significant criteria of a vested rights application, and that even with a vested rights determination, the property would still be ineligible to obtain a certificate of occupancy in its current configuration. The vested rights, first of all, criteria not met. In order to meet the criteria for a vested rights case, the applicant must not only show that they engaged in substantial construction and made substantial expenditures, they must also show that they will suffer a serious loss if forced to comply with current zoning laws. The serious loss determination requires a showing of 1, the owner's inability to recoup expenditures made, and 2, that there would be a decreased level of return for the project. In this case, the applicant admits that they cannot provide evidence of substantial expenditures made by the original owner of the property because that evidence is unavailable to them given the prior owner's bankruptcy. What the applicant fails to discuss is that it was the original owner, not the applicant, that made substantial expenditures. The applicant cannot argue that it is entitled to seek a vested right because of substantial expenditures that were never made by themselves. Further, the applicant was able to purchase this property in July 2013 from the bankruptcy trustee of the prior owner's estate at a highly reduced rate of approximately $1 million. This property consists of 4 attached 2-family homes on a large lot, which is worth significantly more than the purchase price, even when considering future construction costs required to make this a functioning residential property. Therefore, the argument that the applicant will be subject to a decreased level of return for the project is more than overstated when there will be likely a very high level of return given the low purchase price. As such, the applicant is not entitled to a vested rights determination when they do not meet the criteria to show serious negative economic impacts from their compliance with current zoning law. In terms of the C of O, it is my understanding that the property was not given a C of O under the prior owner because it did not have sufficient space for emergency vehicles to access the residential property, especially at the rear end of the property closest to the rear yard. And if I could interrupt my testimony, I appreciate the chair's comments to the applicant about the fire department access, because that is a serious issue. As you know, the oddly placed configuration of the building shows that the unit closest to the rear yard line, 47-10, 198th Street, has a very narrow driveway space in front. Should BSA decide to grant the vested rights application and allow this property to remain in its current configuration, and I apologize, that's my phone going off, it is highly unlikely that a C of O would be granted to the applicant. In fact, the changes that may be required to obtain the C of O may be of the same magnitude as those changes that would be required of the building where the applicant's requested remedy be denied by BSA, including removing significant portions of the building that are closest to the rear yard line and currently inaccessible by emergency vehicles. It is also my understanding that the applicant intends to pave over much of the front portion of the property to address the concerns for access by emergency vehicles, thus resolving the C of O issue. However, such measures could inundate neighboring properties with water runoff from this large property. If BSA grants this vested rights application, specific requirements must be imposed on the applicant in relation to their attempt to resolve the C of O issues, so that new water runoff issues are not created as a result. Based on the foregoing, I would appreciate BSA denying the application. I would also ask that the applicant be required to give us a copy of their submission to your questions, and that we be given sufficient time to prepare our opposition. Thank you, Madam Chair and Commissioners.
All right, is there counsel representing opposition?
No,
No, okay.
and I'm not an attorney.
You're not counsel.
But I do have, as the former chair of the zoning committee of the city council, I do have some expertise in this regard. And we do have zoning experts that I rely on from time to time.
Okay, thank you.
Thank you.
Next speaker.
Thank you very much. My name is Terry Pumari, the Auburndale Improvement Association, the homeowners group for this particular area. We were here at the last session, and subsequently we've gotten some letters from the adjacent homeowners. And I brought copies of them. I'd like to keep the originals, which I have, and I'd like to give them to you. Unfortunately, I don't have a copy for everyone, but you're certainly welcome to make copies. There are 5 people. 2 in particular are directly on the southern portion of this property, and they're complaining about flooding. They've never had flooding. They've been there for years and years, and they've never had flooding until these buildings were completed. They now have rodents, too, and they believe that the property, the building, is too close to their house. Their house is actually quite close to their property line, and then they have this 8 or 9 foot fence, and then when you look over, that's supposed to be where you can park 2 cars in tandem. How you get them out in a fire or emergency, I have no idea. And then there's also 2 cars in the back of that, that's to the west, side by side. So 4 cars have to come out of that, quote, driveway, alleyway, whatever. And it has to be enlarged to 8, which means they have to shave off the building. Another neighbor is opposed to opening the street. The applicant makes reference to using 198th Street on the other side of the property fence to bring the fire department in, and you would have the truck practically having to climb over his actual property, the sidewalk and so on, because I was there on Sunday and Monday. And then they've been complaining about improper drainage. And we're alerted to this paving, concrete, asphalt on that open space, which may have been a part mapped, part the beginning of these buildings by these stairs. All that water is going to run down. And the street from 47th to 48th Avenue, mapped or open, is a pretty good slant all the way down that whole block. So it's running, it's going to go in the house, down the street, and around. Certainly, it's going to be absorbed by the land, but if you have to pave it to have heavy vehicles, it's going to run faster. And we just had a member of the organization complaining about water in her basement and so on. She called the DOB. They came and cited her for the environmental protection because that water is not supposed to be running down your driveway, which it would be doing with this paving. It's supposed to be running into your property. And they're telling her she's got to put in a drainage system or she's got to put in a dry well. It looks to me like the plans call for dry wells, but it's going to be such a slant that it's really going to be a problem. So we go back to the idea of vested rights. We don't believe that the current owner, the new owner, has the right to vested rights because the property, when constructed, did not conform to the zoning regulations, R32, in terms of side yards. And what they were telling the DOB was that they were going to use backyards. They were going to use the side yard on 47th, because the entire property building faces east, and they were going to add it to the corner of 198th Street. And that's going to be 40 yards of a backyard. I don't understand that. And I don't understand how you can have a corner to a map street that's not open. That's fantasy.
If you could wrap up, because the time is...
Certainly. We would prefer, because of the dangers to the surrounding area, either devaluation of the property, that this project not get vested rights. It has to be reworked. This was the the previous owner, that put the property on the perpendicular to the avenue. All houses, and some of them built since he started his operation, are all built facing the avenue, and they're sold, they're rental. Some of them are old, some of them are brand new. I even came across the board for one set of project a little bit further east. Please do not allow vested rights. And we have some serious disagreements with the applicant's last remarks. Thank you.
Thank you.
Would you like the letters from the...
Yes,
okay.
Next speaker, please. Is there another speaker on this item? No? Oh, okay.
Well, Madam Chair, Commissioners, I think I have some homework to do. I would like to be able to respond fully and hopefully satisfactorily to Senator Avella and to the Homeowners Association. So the 4 or 5 weeks that I requested earlier to allow us to put us all together, I respectfully request the board to give me a little more time.
Yes, good
I would
idea.
like to evaluate the comments of the Homeowners Association. I would like to review Senator Avella's comments. I would like to respond to all of the submissions by all parties that I hope will put this issue to rest and/or dictate modifications to our submission to this board to address them or to mitigate them.
Right.
We don't want to say that they're wrong, but on the other hand, well, perhaps they're stating that requests that aren't real in this real world. But we will try our hardest to address everything to hopefully to everyone's satisfaction.
Okay.
And we respectfully request one item, however, that you consider at the end of this process granting the common law vested rights application and the companion GCL applications.
Okay.
Because we believe that the client is entitled to it, notwithstanding the disagreements by other parties.
Okay. So, given our schedule, how about a submission on January 27th? That would give you 8 weeks from today?
That sounds perfectly satisfactory. If there's anything missing, we'll address it at that time.
Okay.
We hopefully will.
Hopefully this will be a
We hopefully will be able to
complete
address everything by that time, but I can't say for certainty.
Well, do you need more time than that? Because we would like to have a complete submission to not like keep going with the hearings. We would like to know that you've answered all the questions.
We'll live with January 27th. It sounds reasonable. It's
Okay.
doable. We just have to try harder.
Okay, yeah, you're actually going to have to work on this starting like now.
Yes.
To be sure you'll be ready then. Okay. So, and then I'll give opposition 2 weeks to respond to that, so they can submit on February 10th, and for a hearing on February 24th. Okay? Or do we need a response to the response? No, okay. So for a hearing on the 24th. And if you want to follow up with anything, please, the interest is in getting the application as clear and complete as possible prior to the hearing, okay?
Absolutely. One request, could you please have your staff have a copy of all the submissions made by all parties, so we can jumpstart responding to them or preparing our response for them early on.
You're talking about their testimony that was just
I'll
given.
scan
That's correct.
Yes.
And also, I'd like to request a copy of a transcript of today's hearings.
Okay,
So
as
we'll
opposed to...
We'll put it together with the submissions by all parties and address everything.
Okay, as opposed to just the video, you'd like a transcript?
Yes.
Okay. Okay, so noted. Thank you.
Thank you, Madam Chair, Commissioners.
Sorry, no repeat. If you have a question, then speak to Tony Matias at the corner or Ryan Singer, the executive director. Okay?
Yeah, I guess I
Okay.
could pull the next case.
Item number 11, 163 through 165 14A Canal Street, Manhattan.
Hi. My name is Alan Gary. I'm representing SRA Architecture and Engineers, and we're representing Ponte Equities. Madam Chair and board members, I believe there are two issues to resolve. The first issue is whether or not we could have moved the openings and the roof level 502, 504, 506 Canal to accommodate the raised floor levels. And the second issue is whether or not the floodgates are an acceptable solution to the floodproofing issue. As regards the first issue, we thought that the sections would show the impracticality of raising the floors while maintaining the existing openings. However, the question of whether LPC would have allowed us to raise the openings or the roof remains. The process of work on 502 is not a typical design, bid, build sequence. After the storm in October 2012, the first permit obtained in November of 2012 was for structural repairs. This was even before the DOB declaration on December 18, 2012. The permit for the interior work only was obtained after an LPC CNE in May of 2013. LPC did not approve the exterior design until September of 2013. Therefore, we had to make a decision on where the floors were being located before LPC reviewed and approved the design. The building has two facades, separated by a curved corner element. After the storm, the entire Canal Street facade was removed, but the Greenwich Street facade was retained. We had to photograph and measure the existing building facades before demolition. The goal was to rebuild exactly as it was, and this was supervised and reviewed by LPC. When we rebuilt the Canal Street facade, we had to align the windows as they were originally.
So, excuse me, are you saying the work was done already? That's what I'm not understanding.
Yes, yes.
So you're saying the construction work was done already?
Yes.
Even though you had this floodplain issue
That's
for
correct.
the first floor?
That's correct.
So then, in the initial construction, were you assuming then that you were using this ground floor for commercial purposes?
We were probably still thinking about it. I think that, the storm hit and there was a lot of, oh my God, what do we do? We started designing, but we're designing and we're getting phone calls from the field, where do I put the steel? The wall's falling down. So the easiest solution for us is saying, all right, we don't know what Landmarks is going to want, but the safest thing for us to do is to put it back the way it was, because we think that's the strongest solution. The whole goal of Landmarks is to preserve. So it's not sort of to preserve something like or in the style of. The goal is really to actually preserve. So they were very focused on that stone lintel, let's save it. Okay, that lintel over here, that relationship between these windows, which is 2.5 inches off, we want to preserve that. So they were very, very particular about us putting this building back exactly the way we found it.
But that was because you were in an emergency rebuild and you were going to maintain the current uses at the ground floor, right? The commercial use of the ground floor.
The uses on the ground floor, okay, are really sort of a separate issue, right? All they care about is, to be honest with you, it's 8 inches of masonry, and it goes up 30 feet, and it has openings, and it has lintels, and it has windows, and that's what we were most concerned with.
Right, but it's not a separate issue in that frankly, the only reason that you're here is because commercial use is being proposed for the ground floor.
There was a reason to go, okay, with residential on the first floor as opposed to commercial. So this is just addressing, this is only addressing the issue of couldn't you have moved the windows or not? This has nothing to do with...
No, they're actually tied together.
They are tied
right?
together.
So if you had known that you were going to be doing commercial on the ground floor, you would have known that, residential on the ground floor, you would have known that you're up against a floodplain issue where you have a residency problem on the ground floor, and then it might have been a different question presented to to landmarks because as of right, you wouldn't have been able to put residential down there without raising the floor, right? So then you would have had to have a conversation with landmarks saying, well, actually, we have to raise the floor in order to comply with FEMA regulations and therefore sill heights, da-da, right?
Well, we're balancing two things, and I think, I think the argument is, which is not this argument, the argument is, what is the best use of the ground floor? Okay, so we have a problem, and we can get a variance, and that's what this conversation I thought was really going to be about, which is, can we put what we believe is the best use on the ground floor, and even though it's in conflict with the law, I mean, we can't make this flood-proof in the sense that the law wants it to be, because it's landmarked. So we interpreted Appendix G as saying, okay, if you are landmarked, you can be excused from this, and we went and said, what is the best use of the first floor?
But it's not accurate that you can't make it residential, you can't make it flood-proof because of landmarks. You're saying you can't make it flood-proof because of the sequence in which you did the work. You went ahead and actually did the work on the assumption that you were going to maintain the floor at the level because at that time it was retail. And it doesn't come up in the conversation until after the work's already in place, and now you're trying to go to a new use, which is in conflict with flood regulations.
Right.
So it's not landmarks that's actually in your way, it's flood regulations in your way, and the sequencing of construction.
Correct. And, the building, regardless of the use, cannot be flood-proofed. Regardless of the use, whether the use is commercial or residential, this building cannot be flood-proof because the openings are where the openings are and the buildings are where the buildings are.
Right.
Okay, so now, if we come to you and we say, listen, we know that there's going to be a problem if we put residential down here, but we think residential is the best down here. And that was the arguments in the other section. That was in the first paper I gave. I said, I didn't really expect to have these arguments, okay, about can we move the openings or not, or the levels. I really expected to have the argument of can we change the use? Is the use of the first floor residential so significantly better than commercial down there that it warrants a variance?
Okay. But you're asking for a waiver of basically a safety regulation. So you really need to establish that the waiver of the safety regulation outweighs the other kinds of values which have to do with your occupancy, right? So you're trying to say that residential use is so much better, therefore that huge improvement in the character of the building or the community or whatever outweighs this safety regulation, which can be met in some other way, right? The safety regulation.
No, the building doesn't become safer because commercial is on the first floor.
No, the building
In
doesn't,
fact,
but
our
risk
argument-
to tenants, there's a reason why it's directed at residential tenants.
But I went through the reason why I feel there's less risk with residential on the first floor.
Why is there less risk?
Because, first of all, there's 3 less tenants. Okay, there's 3 less people to notify. Secondly, a business has no use of the cellar, and a business is now at risk. Okay, so somebody can't come to work, employees can't do their jobs, and it's going to be much more difficult to sell that or, realize that as a consistent income for the properties.
So then, basically what you're saying is all of the FEMA regulations or flood regulations that say that you can have commercial on the floors that are below the floodplain level, they're all wrong? That's not the way it should be going? It should be residential on those lower levels?
We are only looking at these 3 buildings.
No, in general, because obviously commercial being allowed below the floodplain, there's a public policy thinking behind that, that displacing a business somehow or other is more, let's say, acceptable or manageable than displacing a person from their home, rendering them homeless, effectively. So you're saying that in this case, that's not the case in the case of these three
Well,
buildings?
the people in these buildings cannot be flood-proof. That is to say, we can't say, okay, the commercial is out of business, but the people upstairs can stay. We don't have that kind of building. We can't make that happen here. Okay, so everyone has to leave these buildings.
Why can't you make that? Sorry, in terms of evacuation, is that what
In
you're talking
terms of floodproofing, evacuation, the sewer system, this is not a building that, these are not buildings that are large enough or new enough to really be made into a situation where the people can stay upstairs during a flood.
Not during the flood, this neighborhood would be evacuated during a flood, but after the
Right.
flood, their stuff on the second floor would be intact, right?
That's correct.
Okay, that's what this is about. The residential tenants' stuff being intact at the end of a flood. That's what this whole discussion is about, right?
Correct.
And so far, what you've shown us, as far as I'm concerned, and what we discussed yesterday at the review session, was the floodgates that you show require an enormous amount of manpower to install, skilled manpower where it's supervised by a licensed professional. The first set that you showed us were supposed to be bolted to the ground, and the explanation in the tear sheets was that once bolted, then it creates some kind of a seal, and therefore that would prevent the water from going underneath. And now this version doesn't have any kind of anchoring to the ground because you don't have authority to do that, and et cetera, et cetera. So we're not seeing that this is a way of really protecting the interior.
Well, that's the second major issue that I came here with. Okay, so the first issue was the openings, which we've now moved to commercial versus residential on the first floor. What's the best use in these buildings? Without commenting on the law in general. Okay, it's just these buildings, this sort of economic little package. We want to move on to the floodgates because I have the other half of my concept
Sure.
was
Are
on
there
the
comments,
floodgates.
questions on this? I'm still.
I'm a little fuzzy as well, because I think that for whatever reason, that you decided that it's better public policy or just better in general to have residential on the ground floor. You still haven't answered what my question was that what can you possibly do to the building to have some mitigating force to keep water out? And I do not agree that those buildings are such that you cannot think of something that would, at least in some way, prevent water from getting onto the first floor. I'm not saying that everything is foolproof. Your solution is not foolproof. I can guarantee you water is going to get past those barriers. But you haven't shown us, or at least you haven't convinced me, that that the buildings, clearly there's nothing you can do to the building itself that would mitigate water. And I think you need to show us that there's got to be some passive way of mitigating water infiltration. I mean, to rely totally on, human power in the middle of some crisis storm, to go to another site, granted across the street, get the materials, make sure that your licensed professional is there to watch the installation, who's going to sign off on the installation and take that to the building department, because the building department's going to ask about that, and then make it through the storm and somehow then get that off the street. Or there's got to be some way you can look at those buildings and say, there are some things that we can do that's going to mitigate water infiltration. It just seems implausible that relying on human power to do everything.
Well, there are many companies who do this work, and they do this work because, we don't, we have on the first floor a combination of brick, wood, glass, that join together with silicone, and, that's probably where the water's going to come in if something doesn't sweep down the street and break the glass.
But
So-
I think you haven't at least answered my questions about
I don't believe there is
raising
anything.
sill heights, et cetera, because you didn't ask Landmarks those questions. You didn't go to Landmarks and say, look, we're intending residential. We know we have to fulfill some legal obligation here to prevent water from entering these buildings. How can we do that Landmarks could approve? That discussion didn't happen.
And now you're saying the work has already been completed, so we're effectively being asked here to kind of legalize the work, even though, legalize the work for these kind of FEMA purposes, when a simple lifting of the floor would have been possible. The drawings actually show that it actually would have been possible with a little adjustment on sill heights. Landmarks actually often approves dropping or raising sills to accommodate function. There's also other ways of doing it where you don't do anything to the sills. You just drop the floor with respect to the sill, just in that little area to create little pockets. There's all different approaches, but Landmarks is very accustomed to making those adjustments. But what you're telling us is it's too late to make the adjustments because you already did the work. And so it's like you came to us too late. You should have come to us when you wanted to, when you decided to go to Landmarks. You should have, and at that time, you should have already known that you wanted commercial at that level, so that we could have worked in tandem with Landmarks to say, okay, this is how you would need to adjust it. But actually, what we're saying is, so far, that you haven't demonstrated that you can't just comply with the regulations and make minor adjustments to the building, ultimately minor adjustments.
Well, now we're back to changing the building. I don't think that Landmarks would have let us drop a sill one course.
Landmarks is accustomed, as I said, to dealing with regulations that require modifications to buildings. So had they been asked, this would have been a very different discussion, but you don't know that they would say no. And in fact, it's likely that they would have figured out how to work around this.
Well, I have contacted Landmarks. I have contacted John Weiss. I'm going to speak to him because he was involved in the early sort of decision-making about what to do with these buildings. And he may have some insights into, why we felt so obligated to stick with these buildings. These doors all open at grade, which is about 2 feet below the flood level. They all have designs for low sills. That means that the first 4 or 5 feet into the unit was going to be below the flood level, for sure. And so now I've got part of their space. I mean, even if I design this, the proper thing to do is to have the tenants leave. And so then the question becomes, what's our damages? Who's responsible for the damages? Okay, and this is again the reason why these are rental units and not for sale units. Okay,
Why are they rental versus?
because these are people who don't have to replace the kitchen if there's a problem, who don't have to replace the floor.
But what about all their stuff?
Assuming there's a warning, the stuff can be brought to the second floor, to the
Really?
extent that it can.
Your couch, your piano, all that brought to the second floor.
But these are tenants, and they are renting it, and they know what they're
There's going to be a big statement on the front page of the lease at the top that says
yes,
that you're
yes.
going to have to evacuate and that your
They
things on the
that's
first floor will be at
that's-
risk.
That's part of the flood emergency plan.
To have a big announcement on the lease. Any tenant would rent if there was a big announcement on the front page of the lease that says your first floor is below the level of a floodplain, and the last time in Sandy, the flood levels rose to a height of X in the building. Be aware that your piano and your couch will be flooded.
That's correct. That's correct. It's an economic decision by the owner. He feels that's the best use of the property. He feels that in spite of the the risks of something that may or may not happen again or at any frequency, this is what he chose to do. If we have a flood like Sandy every year for the next 2 or 3 years, he's going to go back in and he's going to renovate those buildings. Because he's going to say, this trade-off is not worth it for me. But these buildings have been there almost 200 years. So they...
With commercial use at the ground floor.
And Sandy is an event that, you know, it's the first time in my lifetime it's been. So it's the kind of, you know, event that, you know, maybe with climate change, it does happen more frequently. Okay, but this is the owner's decision, and I think part of it was the inability to get commercial tenants because they had been vacant for a while. And he said, this is what I need to run these buildings.
Okay. Commissioner Otley Brown, you had comments?
Yeah, I just wanted to share Commissioner Hinkson's concern in relying on the aquafence barrier that requires a lot of advance notice and preparation to protect when, you know, we're not only talking about floods here that are announced floods, like in the next 10 hours, a storm is going to hit. There are flash floods that have been hitting with greater and greater frequency, causing as much or even more damage. And so I don't see that the aquafence is really going to protect property or lives in the instance of flash flooding. And so that's why I kind of agree with Commissioner Hinkson that there really needs to be a solution, perhaps a creative solution, that somehow protects from within, that doesn't require a lot of advance notice and setup time.
Okay.
Well, your proposal is really to dry flood-proof the first floor, which is not permitted according to the regulations for residential use. So you're asking us to do something that is acceptable for commercial use. And from my point of view, I couldn't see that, notwithstanding the assumption that the building might sustain a lot of damage in another flood, with certain precautions or safeguards, in my opinion. And I don't think you've presented us those precautions or a convincing argument that this flood-proofing mechanism would work. I don't see any verification from an authorizing agency that these are acceptable to FEMA or to the building department. You know, I felt that the fact that you were not going to secure them to the building or to the sidewalk was really not acceptable. I didn't see any calculations.
I know, but let me go to my second half, which is not that long.
Okay.
When I got done, actually after the pre-hearing, I called Adam Goldberg, who's the manufacturer's rep for the aquafence. He said that FEMA does not recommend manufacturers. It's not allowed to recommend the product. But he did say that he installed one of these fences at the Brooklyn Aquarium Shark exhibit. It was filed with the DOB, approved by the DOB, and approved by the DOT. He said that the Department of Transportation will approve stainless steel anchors in the sidewalk, as long as there's 5-foot clearance, with caps on it. So he says these units can be anchored to the sidewalk. He said that it would take about 90 minutes for 3 or 4 guys to install it. He has a licensed engineer who has done the calculations for his product, and so we can get him to do the calculations for this particular product and this particular installation. So what we can do is we can file this fence with the Department of Buildings.
Wasn't
Okay?
that, I just don't mean to interrupt you, but wasn't that used because there was a failure actually at the tank, not because of the storm? Wasn't that conditioned because there was a failure at the tank?
I don't know.
I
don't know.
I researched that because I don't think it was
Okay.
under storm conditions. I think they had a failure at the tank.
Okay, all right. We'll research it, but we're more than willing to file this with the Department of Buildings. Okay, get their approval, go to the Department of Transportation, lay it out, get the structural calculations. I mean, this is something that we can do.
I also think if you need to have Landmark's approval, to put anchors into the?
No, once I put it in the sidewalk, I don't have to touch the building.
I
That's what he told
still
me.
don't see that, because you still need a gasketed connection to the building to prevent
If the
leakage.
shear in the ground is enough to push it into place, might be enough. But I'll ask.
But the first set of submittals you gave us relied on connection to the sidewall. It actually had a fin on that
What I
set of
gave you
connections.
was all that I had, which was
Okay.
an Army, U.S. Army Corps of Engineers report on a system that is related and is not our system, but it's close. It's in the same family. So I didn't realize how much information you were going to require on it. I didn't, in fact, before the first submission, file the fence with the
Well, in
building
fact,
department.
we read the submission, we read all the specs, so, and the specs described how it would be, how to make it effective, which was anchoring both to the ground and to the sidewalls with fins, and there was a description even that you were going to get permission to install fins, or at least install the anchors to receive the fins inside of the on the building itself from landmarks. Not to say that it was a believable solution then, in the sense that it required so much manpower and so much coordination, and that, again, we still have this problem, which you're not really overcoming with this fence. The shark tank at the New York Aquarium, forgive me, there's a huge staff there who are skilled, who maintain the building, right? And I dare say that there's probably engineers that are on retainer with the aquarium that can come at a moment's notice and so on. This is a totally different case where you're talking about a private house and
But it's not.
a bunch
It's
of
Ponte-
guys.
It's
you know,
Ponte
coming.
Equities. They have many properties. They have a staff that is full-time staff,
Who
maintenance,
will be stuck
construction.
in Brooklyn because they can't get out because there's a flood.
Well, this is well, then, the flood emergency plan is a flood emergency plan. It commits him to a certain level of action. And the penalty for his inaction is going to be additional costs. And, but this is the risk that he takes by owning a building that is in a dangerous area, in a flood-prone area, and he's saying, well, there's a cost benefit here. I know that, it's, every 20 years or every 50 years, I'm going to have to rebuild this building or do something with this building. And, but the rents that I get cover that expense. So it's really trying to get a property to generate enough income so that a private person is willing to maintain it. Otherwise, it's lost to the public good.
But getting back to requirements, I mean, the C of O is required to note that the building is dry flood-proofed, and basically, the residents would be at risk. So I think what the chair recommended is making a requirement in any lease that anyone signs would also be a way of notifying any potential tenant that they must evacuate and that there is this danger involved to themselves and their property. I also feel that your emergency action plan doesn't really relate that emergency in a very definitive manner. When you talk about the purpose of the emergency action plan, that is to evacuate the building and protect the tenants. And secondly, is to protect property.
Right, I thought that was clear, but I can review it.
I didn't really think it was very strongly worded.
Okay, then I can go back and revise
State,
that.
this is the risk, this is
But
the flood
this is-
elevation, this is what happens.
This is going to be posted in the mailroom. So every day they pick up their mail, there's the posting, flood emergency plan. If this happens, call, get out, the high ground is
But it will
2
be part
blocks
of
up,
their lease also.
and part of their lease.
And as I said yesterday, I didn't see where you are going to comply with certain parts of Appendix G regarding the design, the professional who's going to be responsible for all the inspections and, monitoring the installation. You're familiar with all that?
Yes, yes. And so what we'll do, this is the next stage. In other words, I'm doing this in stages as opposed to doing it all at once, because we're trying to get an approval, get an idea of what is necessary. So
Well,
for the next
this
stage,
is
you
from-
need to see approved drawings, okay? You need to see an engineer's statement. You need to see a copy of the lease. You need to see,
Well, calculations, assuming that
structural calculations.
assuming there will be riffraff and debris and large
Exactly.
timbers floating
That's
down
correct.
Canal Street.
That's-
Exactly.
That's correct.
So to say that they're not going to be anchored to the sidewalk is, not sufficient.
Right. So, no, we will do an anchoring scheme.
Okay, but before you, before you do that, so I think we've kind of made clear, though, that this isn't real, that the floodgates as proposed aren't an adequate solution to really flood-proof this. And warning the tenants that their stuff is going to be destroyed isn't really meeting a public policy. I think that Commissioner Hinkson's question about a passive system that actually works to dry-proof in some way this, I mean, you're not doing any work on the interior of the building to try to create some kind of, I don't know, a bathtub condition, drainage condition, something. I don't know if there is a solution, frankly. That's one reason why you're not supposed to occupy below the level of the floodplain, right? So unless there's a way for you to actually, unless you can think of a submission that will persuade us that the floor will remain dry, not by relying on guys coming from across the street when they really can't get into town because the area is now cordoned off because the floods are arriving in any minute now, but something that is actually going to actively work to protect the building. I don't see that we don't have a case here. So if you want more time to think about an alternative, we can take more time. Otherwise, I don't think that you've got a consensus here, that you've got a case, in which case I think we would need to close the hearing. So it's your option. Do you think there's something else that you can do? We can give you some time to go back and do more research, but at the moment, this isn't it.
You want something that the tenant can sort of close up on the inside. He steps out of the door, shuts the door, and he's got a barrier inside that protects from the water.
Well, it's more than that. Water's going to be coming from below.
That's
right?
waterproof. That's waterproof.
Okay, that's waterproof. You actually haven't addressed that. So water's going to be coming from below and from the sides and from the windows. What are you going to do?
Right, it's
That-
the windows.
That doesn't require guys to come from out of town.
But the purpose of the floodgates is twofold, and it's something that we cannot do with the passive system. It's to protect from debris and to protect from wave action. So if I have somebody close up the building, even with gates on the front or gates on the back, the waves and the debris are still going to hit the building. So that's the real purpose of floodgates. They're invented and they're being used for a purpose. And there is energy and time involved in setting them up, but they do have a value. Okay? And we happen to think that these buildings, have that value. Is it foolproof? No, nothing man does is foolproof. Okay? We're going to suggest a passive system that protects the lower half of the doors and windows that someone will be able to put in place and then leave the building.
And look at raising the sill heights. Look at raising your sill heights and seeing what you have to do.
Well,
Because you have not had that conversation with Landmarks, and I think it's worth having that conversation, at least to my satisfaction, that there is nothing you can do to that building that doesn't rely on personnel.
All the doors go down to...
Understood, but take one thing at a time. If I can deal with my windows, then go to the doors. How do I deal with a door?
Doors have floodgates that you can actually see.
There's a multitude
So
of...
somebody's putting in a floodgate.
There's a multitude of solutions if you look at this individually. I think maybe you're looking at it sort of, I've got to protect all of this building, and how am I going to do that all at once? I think you have to, as a designer would, look at your different building elements and figure out what you have to do to protect each element. Start from there and then grow out. I understand that these flood walls work in situations, But I don't, at least I would not look for that to be my primary source. I would look first to do what I needed to do to the building to make it as foolproof as possible. And then if I had to augment, maybe that's some sort of solution, but not as your primary solution because it just simply relies on too many human factors. And we fail, it fails. So, look to the building.
Okay, all right.
Are there any speakers on this item? Okay, so I think it's going to take you some time to figure this out because you're going to be doing some research. So what about another submission at the end of January? Would that give you enough time to work on some other design schemes? And even if it requires raising of some sills, talking to Landmarks about that?
Yes, we can, I'll begin that conversation today. The hearing would be the end of January?
No,
so
your
our
submission would be in the end of January to give you enough time to do this?
Yeah, that'd be fine.
Okay, so submission January 27th for a hearing on February 10th.
February 10th. Can I call Tony if the owner wants something a little sooner?
No, you have to make it.
No, that's the.
What's an earlier one then?
Submission January 13th for a hearing on the 27th.
Yeah, that's better.
Okay, but we want to see a full submission, and we want to, needs to be something that really persuades. You hear a room full of skepticism. So far you haven't persuaded.
How far do you want me to go with the flood gates? Do you want it filed with the building department? Do you
No,
want
it
me to
shouldn't be
bring it
filed
under here?
because at the moment,
Right.
we're not persuaded the floodgates
I can
are
bring,
adequately.
with enough notice, I can bring the manufacturer here. I can get structural calculations done, if you'd like that.
But the subject of the floodgates is that it depends on people to come and install,
So
right?
you're more concerned with a primary system?
Yes.
That's more passive?
Yes.
That's something that the tenants can do?
Or that's already installed, not just that the tenants can do, that's already installed.
Okay.
Okay,
Great.
thank
Thank
you.
you.
Thank you.
Next case, Madam Chair? Okay. New cases, item number 12, 66539A, 10714A, 5557 West 44th Street, Manhattan.
Good afternoon, Madam Chair and Commissioners. I'm Melanie Saddock from Fox Rothschild on behalf of the applicant, City Club Hotel Realty LLC. I've been to the review session, and I'd like to provide a brief presentation addressing many of the issues that you've raised, and then my colleague Jerry Johnson and the architect are here to answer any further questions. I'm here on two applications related to the proposed 9-story enlargement of the City Club Hotel located on the north side of 44th Street between 6th Avenue and 5th Avenue. City Club Hotel is a small premier luxury hotel located in a building that was built in 1902 and was originally housed by the City Club. The hotel has a unique and thoughtful design that effectively strikes a balance between a modern, chic hotel and one that honors and highlights its history as the City Club. This property was first before the board in 1939 when the owner sought to convert the 4th through 7th floors of the club to office use. That conversion required a few waivers from the board, namely a fire tower and the width of the rear exit stair that was 2 inches deficient. In the late 1990s, the owner sought to convert the building from office use to its current hotel use and ground floor restaurant use, to divide the 3rd floor into 2 floors, to expand the 9th floor, and to install and reinforce support systems in anticipation of a future enlargement. At that time, the Department of Buildings addressed the 2-inch deficient exit stair, and on reconsideration, determined that it could remain so long as the stairs in the future addition were complying 36-inch wide stairs. DOB ultimately signed off on those applications, and a certificate of occupancy has been issued for hotel use with the non-complying inner courts, providing light and air for 16 hotel rooms, and the 2-inch deficient exit stair. We're here today to talk about the proposed enlargement to the hotel that was anticipated in the late 1990s. In particular, we are seeking a waiver of the multiple dwelling laws requirements regarding the size of the courts that will be in the 9-story enlargement. We are also asking for an amendment of the 1939 waiver to reflect that 9-story enlargement. The enlargement complies with zoning. It will provide inner courts that are significantly larger than the existing inner courts in the building. But those inner courts will not comply with the MDL's requirements that they each be 1,200 square feet. That would result in an awkward, narrow, and inefficient complying building. No windows will face the new inner courts above. And again, only 16 hotel rooms in the existing building face the existing inner courts. As to the sunlight, the reality is that the existing courts do not get direct sunlight in the first place due to the building orientation in relationship to the sun. A complying enlargement would have the same problem due to its orientation and location on the lot. In response, the applicant will increase the ambient light in the inner courts by painting them white, the existing courts as well as the proposed, and provide mechanical ventilation. The proposed new courts have been designed to be as large as possible, given the constraints of the lot size, the zoning regulations, and the design of the existing below, as well as the need for an efficient and viable hotel. As to the 1939 case, we are asking the board to amend the grant to reflect the proposed enlargement and that the 1939 case be superseded by the MDL case so that there's a single set of approved plans going forward and a single calendar number going forward. A fire tower is no longer required by the 1968 code, nor is a fire escape that the board had previously required as a condition of its original grant. However, the deficient stair, the 2-inch deficient stair, has been there since 1902 and remains deficient to the 1968 building code. As provided in the architect's letter submitted with the applications, the building is compliant with the 1968 code, and the enlargement will be compliant with the 1968 code. And in fact, the life safety systems will comply with the 2014 code. The fire alarm will be replaced and compliant with the 2014 code. New auxiliary radio communication systems will be installed. The smoke purge system will be modified and expanded. Sprinklers are existing in the existing building and will be installed in the enlargement. And the stairs are enclosed in fireproof partitions in the existing building and will also be enclosed in fireproof partitions in the enlargement. We're happy to address any further questions that the board may still have.
Okay. Well, actually, there were quite a number of questions at the review session. Some of them had to do with, for example, the inner court, the issue about the inner court really, the existing inner court, is that when you add the 9 stories, you're creating a tunnel, basically, like a canyon. And you're only enlarging the courtyard a little bit around the existing court. So effectively, the tunnel has 9 stories for some little bit of light to filter its way down there, granted it's not direct light. And you didn't actually address that. There's no section provided, and there's no analysis of what will happen when you neck down effectively that courtyard with this tunnel. That's the first. The second was the floor plans show that the building has sort of an octagonal back. So you have a 20-foot rear yard, and it holds only a portion to the 20-foot rear yard, and the rest sort of facets back. And it's not clear why that's done, because if you just built full to the rear lot, sort of to the rear yard line, so to the 20-foot line, then you'd be able to build across and extend the courtyards longer. So arguably would allow more light to funnel in and down into the existing courtyards. So if you could have, I mean, that's probably a question for the architect. I'm not sure if your architect is here.
I think Mr. Johnson will respond.
Jerry Johnson for the applicant. So in terms of the courtyards and the existing courtyards and the light, we previously had looked at the idea of preparing some kind of a light study. And since it's not really direct sunlight that's the issue, it's ambient, it's very difficult to do a study to get significant readings from all the people that we've talked to so far. What we propose to do is, in addition to the painting and lightening up the interior courtyards as well as the materials on the new courtyards above, providing artificial light sources that provide a minimum illumination, and there's a building code section pertaining to courts, and we will cite that in our subsequent submission, and light levels to make sure that those courtyards have a minimum amount of light within. So it'll be increasing the ambient light that's existing to a level that's compliant or greater than what the building code requires. In terms of the back of the building, the reason that the back is the shape that it is, and we will make it clearer in a submission with a plan, is that the building in the back actually has two 8-foot side yards that have windows on them. So when you get above the 8th floor or the 9th floor, actually that building is as wide as it can go back there. There are rooms down below that use those courtyards so that we can't fill those in up above. So the middle of the building is as wide as it can go back to the 20 feet. The corners that are chamfered it was a design issue for the windows and the way the room's laid out. And so that's why we haven't extended those back further, because down below the plans have courtyards, like 8-foot side yards that are not.
Right, but why, okay, I see those courtyards, but why doesn't the building then extend perpendicularly as opposed to chamfered? Wouldn't that give you some more space to play with?
It gives a little more space in those rooms, but it wouldn't add significant more rooms to those levels. I mean, it was a design consideration. We can address that further in writing and explain it.
Mm-hmm. Okay.
But that's why the back of the building is the way it is.
Okay, because if it gives more to those rooms, then you can give a little more to the other room, and then you have more room to expand the courtyard, arguably.
The issue with they've been designed to have 4 rooms in the back.
Right.
And one of those rooms is ADA compliant. If you push the courtyards further out, the rooms get squeezed so that, it's my understanding, we lose 2 rooms in the back, or at least one. It becomes a 3-room situation instead of a 4. And we can address that further in writing and explain that in more detail.
Okay, and I think there was also a question with respect to the ADA compliance. So can you provide information about, so there's a certain percentage of rooms that need to be ADA compliant in the hotel,
That's
right?
correct.
So why do they need to be on the new floors? Why can't they be on another existing floor?
They can, but with the number of rooms that are being provided, some of the rooms on the upper floors need to be ADA compliant, and we will address that. We'll explain it exactly.
So there's a percentage
It's a
of
percentage
new construction.
Right. Well, it's a percentage of the overall rooms in the hotel. And theoretically, we could, if all of the rooms down below could be converted to ADA compliant, then we could handle it that way. But that would then be a problem with down below. And I believe there might be some requirement for the upper levels as well, the new construction.
Okay, so if
we'll
you
address that more in writing in detail.
Okay.
If you have that.
Okay, and then the other question really was, and also, why is Court A so much smaller than Court B if it's basically the same layout?
The courts themselves, it has to do with the way, I believe, the way the building is configured with the stairs that exist and the rooms working out, and we will address that
You
further in
should take a
writing.
look at
Yes,
that.
we
I
will.
think it's because one room's bigger than the other.
But
So maybe that's the ADA room?
One is
I don't know.
ADA, that's correct. The one on the east side.
The one on the A courtyard?
Right.
Okay. And And then with respect to the stairwell, that was the other thing. So we really do need to see occupancy calculations in general to understand. So you've got this substandard staircase to which the scissor stairs from the upper portion, the new portion, will be directed in part, right?
So the scissor stair is on the west side of the building. As it comes down, one scissor stair goes in the existing east side stair.
Which is
and
a complying stair.
Which is a complying stair. And the other one, then you cross through a fire-rated corridor and go down this existing substandard stair.
Okay, so you're adding a certain amount of load to that stair. So if you could talk about that and, okay.
We'll do that in the submission. It's our understanding that it's compliant with 68 code. The DOB has looked at it and they have approved the existing stairs entering into these stairs. And we will give you more detailed writing on that.
The stairs, is it only on certain floors where it's non-compliant, or is it the entire existing building?
It's the treads as they go down from the 8th floor down. They're
Oh, so
2
the
feet 10
entire
inches.
building? Because it looked to me like it started at around the 3rd floor and below.
No, there are treads up above that are, the requirement for the BSA was that all of those treads be no less than 2 feet 10 inches, and that's what the BSA approved plans show, and that's the existing conditions.
Right, okay. So I guess part of the question then, the other question was that there's something referred to in the submission where Commissioner Livian had made a comment that it was okay if you kept the 34-inch stair as long as there was the 36-inch stair. What was that about?
The issue is that the reconsideration that was granted in the late 90s allowed them to maintain the existing 34-inch stairs in that western or rear corridor as long as any new stairs up above that were constructed or anticipated to be constructed, meaning the new construction that we're talking about today, complied with code and had at least 36 inches.
Okay, so we're
That's
talking
what
about
that
the
was. That's
the
correct.
stairs above?
That's
Okay.
correct.
Okay. And, okay, I think there was, so if you could make those submissions, just so make it clear about the occupancy requirements for the stairs in terms of occupancy loads and unit of measurements and so on. I mean, I didn't see any calculations like that provided.
Correct, we
so
will provide that.
we have that. Also, I understand there's a disconnect between the certificate of occupancy and the plans.
Yeah, I can explain that. On the second floor, the C of O, I believe, says there's 8 hotel rooms. But when you look at the plans, it looks like there's 9. So this will tie into another question that came up at the review session about the sky lobby and the need for a sky lobby. The hotel, when it was being converted and renovated, leased most of the ground floor to a restaurant use. And it took up most of the lobby space that's there. So you have a very small lobby that you enter, you check in, and then you go directly up to the rooms. In order to make up for the loss of kind of more communal seating or a business office or places where people in the hotel could go and sit and have a conversation with others, one of the rooms on the second floor was converted. It's the one above the lobby, so it's the one in the front west side of the building, was converted to a kind of a common area, common room, business office, where they could sit. So and in the proposal, that will be converted back to a room. There's going to be a more significant lobby upstairs where people can go during the day. Guests, when they come in, they check through the checkpoint during the day, and they can go directly up to the elevators, and it'll be a much more pleasing reception area, more functional. There'll be more room. People can meet people. They can have a coffee. They can sit down. They can talk. They can congregate in an area that just doesn't exist today. And it's at a location of the hotel where, with the sky exposure plane in this, it's Midtown, so with the setback requirements, the rooms at that location would be so compromised in terms of their width that you can't really put rooms in those locations. So
that's what I was going to ask, because you have that in your proposed complying as well, and you're making the argument that you're losing, in a complying situation, you're going to be losing units losing rooms. And so my question was, why wouldn't you just lose the sky lobby and make those rooms, but you don't exactly say why those rooms would be compromised and why you wouldn't be able
Right.
to
We will
have
clar-
them. So
I mean,
think-
it's because the sky exposure plane is pushing the building back, and you have the elevator cores that are right there, so you can't, you just couldn't, it's not.
If in your
We'll
next
explain
submission,
it.
you could, show that, that would be
We'll explain it.
helpful.
Also, the C of O on the third and fourth floor
Yes.
doesn't comply with your existing plans.
It does, but, we were looking at that after it got raised. It's interesting. It says that there are 6 rooms, and then it says 7.5 rooms. And when you look at the plans, we have 6 rooms, and then we have on the third floor 3 rooms that are connected to the mezzanine level, which is actually the 4th floor, and there are half rooms by staircases. We're not sure why the DOB called it 7.5 rooms on the 3rd and 7.5 rooms on the 4th. We will find out that answer and we'll get back to you. But that's the
legal condition,
that's correct. That's the legal
So
condition. It's what the
you could
plans
show
are.
us those plans also.
Yeah, we will. I mean, I was confused because you would think that if the main room was on the 3rd floor, it would say 9 rooms on the 3rd floor and then 7.5 on the 4th. But we will find out why DOB classified it that way. That's the way they did it.
Okay. And then another question was about the reliance of your courts on the adjoining courts, right?
Yeah,
How do
we
feel
were,
about
that was included because we understand it's actually an existing condition. It's a mitigating condition for the courts.
Mhm.
We understand that we have to comply, we have to make our courts, they have to live on their own because you
Right.
don't know what's going to happen with the adjacent buildings in the future, and we have to make our courts. That's why we're suggesting the artificial light sources and getting back to you on that and
Mhm,
explaining
okay.
exactly what we'll be doing.
Are either of the buildings to your, whichever direction that is, east and west, or north and south? I don't actually know. Is that
It's the Algonquin and the Iroquois, and we believe the Algonquin is a landmark.
landmark? Okay.
But I don't believe the Iroquois is.
Okay, so if you
And both
could
of those,
check
we
that,
will.
and that's relevant to
Yeah.
your discussion as well. Okay.
And both of those hotels rise to, I believe, 12 stories.
Okay.
So about 4 stories higher than us.
Okay, that would be good to address. Okay, so are there any other comments on this? Are there any speakers on this item? So let's see if I can summarize, because it's kind of a lot of things. So we'd like, well, this would just help with the statement of facts. Can the statement of facts be revised to have calculations about the intercourt compliance for the
Yes.
enlargement? Yeah, so that we understand how you get to 1,200 square feet, because that was just a leap. And then a discussion about what you're going to do about the fact that light and air, the light is being restricted, so you're talking about lighting and mechanical ventilation, and to the extent that you, and provide sections through the courts so that we can understand that.
And color code them the same way you did your plan, so
We will.
that it's all coordinated.
That was very helpful, by the way. It's very easy to read. Applicants out there take note. Very easy to read when it's color-coded. You could talk about why the Court A is so much smaller than Court B, and the ADA regulations with respect to the requirements on these upper floors. Talk about the adjoining hotel buildings, the Algonquin being a landmark, and your understanding that you can't rely on the adjoining property. Explain why you can't extend the building back, but if you could show even a sort of a schematic plan of what would happen if you removed the chamfers and extended it all to see whether that would ameliorate the problem a little bit. With respect to the size of the stair, to provide the calculations that show the occupancy load that is sort of dumping down into that undersized stair. And then, what else did we have? Describe the disconnect between the certificate of occupancy and the number of rooms actually. And discuss the sky lobby and why that was installed, proposed like that. Okay, did I leave anything out, anybody? No? Okay. Okay, thank you. And so, I don't know how much time you need for this, but I think we're moving into January. So our next hearing is on January, do we have time on the 6th? Is January 6th? We have time. January 6th is our next really available hearing.
And that would require a submission on the 16th, or can we do it
It could be a
sometime
submission,
after?
for instance, on, I don't want to make you do this on New Year's. It could be a submission on
we
the
want it
30th, for example, of December. Is that good?
That would be perfect.
Okay.
Is there a possibility to close the hearing? With
It's
the option
possible that
with-
we could close and grant. Yeah, there's a possibility, yeah. So let's take a look at what the submission says. That has to do with what we learned.
You've just put the challenge to us.
Okay, there you go. Live up to the challenge. Happy New Year.
Thank you very much.
Okay, bye. I think we're just going to go through decisions now, and then we'll take a break, because it's already almost 1 o'clock.
Zoning calendar decision items. Item number 13, 6513BZ, 123 Franklin Avenue, Brooklyn.
Okay, this one, we were deferring the decision to January 6th, I mean?
January 6th?
Yeah.
Sorry. Yes?
Yep.
Thank you.
Item number 14, 26613BZ, 515 East Fifth Street, Manhattan. We'll put it on the same calendar as the other one?
Yeah, right.
Item number 15, 4214BZ, 783 Lexington Avenue, Manhattan.
Good afternoon, Eric Palatnik.
For a motion to grant?
Oops, sorry, 1 second. Went too fast for myself. Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you.
Thank you.
Item number 16, 11514BZ, 85 Worth Street, Manhattan.
With this one, I think we were going to defer decision to December 9th because we're still waiting for the fire department. Is that right?
That is correct. Thank you.
Thank you. Okay, so we're going to take a 20-minute break. Is that good? So we'll be back in 20 minutes. Sorry, we're all, we're melting here, so. Okay, thank you.
There's somebody in that room, so.
There's somebody in that room?
Yeah.